everybody. Welcome back. Welcome back. It's been a minute. Oh, it's good to be back in my studio. Good to be back with my fish. Can't say it's great to be back with Karen Reed. I mean, of all the cases that really should have ended the first time around, yeah, we know how that one went. But I have to say, as far as a hearing to come back for, I'm pretty excited about this. I'm very intrigued. To see what's going to happen here, because I'm certainly expecting that Judge Cannoni is going to bend over backwards to be dismissive of the arguments that the state's raised, that the defense has raised, to kind of wholesale adopt the Commonwealth's position. But there's some challenges as far as her being able to actually do that. One of the big questions I know everybody has, I certainly have, are we going to get an evidentiary hearing on this? It certainly seems that it's anticipated that something like that would be necessary because we got 2 days set aside for this hearing, and you don't need 2 days to argue a legal motion. So at least when they scheduled it, it kind of seems like they had that on the radar. Like they're aware this is going to be something where you may need to bring witnesses in, you may need to put them on the stand, you need to develop a factual record of what's happened in order to rule on whether it justifies any type of sanction up to the sanction of potentially dismissing the prosecution as the defense is asking for. And there's definitely a lot of reasons why, just from looking at the motions themselves, that seems like it's not only appropriate, but kind of necessary. And it's because, number one, we didn't get evidence from the Commonwealth. We didn't get affidavits. We didn't get sworn testimony. We didn't even get, a verified type of response from the attorneys. Oh, I went and interviewed Lieutenant Fanning, for example, and Lieutenant Fanning would testify that he was never in the courthouse, yada, yada, yada. So we've got these, representations about what the facts are, but we don't have any kind of firsthand admissible testimonial type of record about what they are. And so that in and of itself seems to me that's going to require evidence. It's going to require it. Same thing with the issues relating to this video, the production of the video, how exactly this video was handled, because boy, that explanation has been all over the place. It's been all over the place. That first we heard the whole system is set to overwrite after 30 days. And so video from back in January of 2022, it would have been overwritten in February 2022. It's no longer going to be available. But they just starting to make noise in the courtroom. So that's the first thing we heard. But then we hear that there's a bunch of video on an iCloud that some detective, some now retired detective downloaded. And then we hear that it's on some drive, on some external drive. Then we hear like it's in a paper file. It's just this explanation is bizarre, and it's particularly bizarre when video continues to be produced long after February of 2022. The Commonwealth's own explanation is that, they didn't really even learn that this video existed until April of 2024 during the grand jury testimony. And then at that point, they went and got it and produced it. Well, how would you get it then within that time frame? And how have they been able to selectively go back and continue to get new sections, new chunks, whatever, of this video? It's all just very fishy. It really smells. And I mentioned the other day I was on Melanie Little's stream on Sunday, which was awesome. I'm so glad I finally got to like sit down and meet her in person, because she's obviously like the OG on this case. And one of the things that I mentioned was this was one of the upsides I saw for the defense with the possibility of a second trial. Way back when the mistrial was declared, you know, very disappointing, because having watched the entire case, all of the evidence, quite clear to me, Commonwealth did not prove that she hit John O'Keefe with a car. So I certainly felt she should have been acquitted. But when you have a retrial, there's certain advantages to that. And so one of the questions was kind of always, well, who's going to have the bigger advantage from that, the Commonwealth or Karen Read? And it was a rare situation where I felt that Karen Read, this is going to benefit her much more than it's going to benefit the Commonwealth, because they've already got the Commonwealth's witnesses nailed down. They've testified under oath. They're now stuck with that story, or it just adds to the impeachability of their witnesses. They've seen the whole Commonwealth's theory, you know, their strategy for how they were going to deal with the case, which of course, you know, there's some flexibility to modify that. And we're going to see some modifications. We already know they've got some new experts, obviously a whole new attorney running things. So we can expect they're going to handle things a little bit differently. But one of the big advantages that I saw was these weak points in the Commonwealth's case. This is their opportunity to start pulling on those threads. To pull on those threads and see how it unravels. Do they find a knot, or do things just kind of start to unweave? And this video, it's just such a good thread to be pulling on, because it's sus as hell. When we saw that in the trial and it came out, this whole video is inverted, which of course the Commonwealth never presented. They never told us it's inverted. In fact, they structured their testimony in such a way to make it seem like what we're actually seeing is just the normal, ordinary perspective, because the whole point of showing it to us was to say, see, there's no police officers near Karen Read's right rear tail light. But when you look at it in the correct orientation, yeah, there's a bunch of them over there by her right rear tail light. This video is super sus because people are vanishing and appearing out of nowhere. It's clearly like skipping. Parts are missing, things that you can't see. And that just adds to the overall sus characteristic of this video evidence as a whole, because it's just such a remarkable coincidence that the only time this video is malfunctioning is when you might get a view of Karen Read's right rear tail light. So it's just quite a coincidence. Awfully unfortunate for the Commonwealth, because the one thing that would really solidify a case against Karen Read, would really present good evidence that there was some kind of impact with her car on the night of January 29th, or the early morning of January 29th, would be that tail light, the condition of that tail light the very following morning. And the fact that they had so many opportunities to be able to present that, to be able to document it. It could have, as soon as they walked up, Trooper Proctor and Yuri Buchanan, as soon as they walked up to her house in Dighton, her parents' house, saw the SUV in the driveway, and right in their reports, oh, we saw the taillight was cracked. They immediately see it. Did they bother to document it? When the car is being towed, they don't document it. When they're moving it, when they're pulling it into the sallyport, when it first gets there. All of these opportunities they had to preserve what's a pretty important piece of evidence in their case, and they didn't do that. They instead rely on, well, we're just going to testify about it, and so you have to believe us. We're going to tie this fact to the credibility of those law enforcement witnesses and the general overall tendency that certainly judges and often juries have to believe that law enforcement is telling the truth, because that's what they want to believe, because it's kind of scary to think law enforcement might be making stuff up. They might actually be framing somebody. People don't want to think that. So this video is just one more piece of this very sus set of circumstances around this taillight. That's such a critical part of the Commonwealth's case, and yet none of it was preserved. And in fact, the very video system that should have captured it all just very coincidentally malfunctions at the exact moments when we should be seeing it. So it's a great thread for the defense to be able to pull on and to dig into and to challenge and to require a more full explanation. Who all had their hands on this video? How did this video go from being captured by the cameras, stored through whatever DVR or whatever system that they have, downloaded, secured, and now produced? And that's the kind of thing that so far, I think we need some evidence for, even in the response that we got from Mr. Brennan from the Commonwealth. Of course, he sets forth a version of events that is unsworn. So kind of no value from an evidentiary standpoint. But even the response, it's remarkably short on details. There's a lot of passive voice in there. There's a lot of somebody did an investigator. I know there's like, oh, an investigator downloaded it. Okay. Which one? Which investigator? Let's start pulling on these threads and let's get that investigator on the hot seat and make them answer some questions. When did you do this? Why did it occur to you that this would be necessary? What steps did you take? Who did you hand it off to? How did you secure it? Did you consult with anybody about the metadata, how to preserve that, how to do a forensic extraction? Is this always how you do it? Is there a policy for how you're supposed to do it? Did you follow that policy? All of these types of details are where the truth is going to come out with respect to this video. And is this all just legit and an unfortunate series of coincidences and bad circumstances that have just regrettably deprived the Commonwealth of this very, very important evidence? Or is there something real sus here, which is kind of how it smells? Is there something real sus here? And so the $1 million question is that going to happen? Is that going to be what we're going to get? Is Judge Canoni, is she going to see things that way? Because, you know, you put law enforcement on the stand, the more times you put law enforcement on the stand, you might catch them in a lie. And if you catch law enforcement in a lie, oh, it's not good for that law enforcement, not then. Not in this hearing, and certainly not in the future, because that's Brady stuff. It's Brady kind of testimony. An officer testifying falsely, that affects their credibility, so that's impeachable, and that's got to be disclosed. So I expect a very strong resistance on the part of Judge Canoni to having an evidentiary hearing here. But I just am having a hard time seeing how, under the circumstances, she might be able to justify that, just given what's alleged, given the insufficiency of the response from a factual standpoint. So really the best way to get there, if I'm looking at this as a judge, looking at it as a lawyer, and you know, how you can potentially challenge what she does with it, the only way I really see her getting there is if she concludes that even if everything that the defense alleges is true, it doesn't justify a sanction. It doesn't constitute misconduct. It doesn't warrant any kind of dispute being fleshed out. That's her way to avoid an evidentiary hearing, is to take the defense's allegations as true. But that's kind of a problem, because if you take the defense's allegations as true, it seems like you've pretty clearly established at least some discovery violations, at the very least some discovery violations that affected the first trial, their ability to fully and properly defend at the first trial. You know, some shenanigans with Lieutenant Tully and his prepping of the McCabes. Which McCabes now we don't even know, because apparently that's an inconsistent report. Was it Matt McCabe that went with Jen, or was it Allie that went with Jen? According to Tully, it was Matt McCabe, but according to Jen McCabe on the stand under oath, it was Allie. And then this whole issue of the jury tampering, which is that's particularly fascinating to me. And I just don't know how much we're going to be able to hear about that, because for some reason the sidebars are impounded. I missed something while I was gone as far as that whole process goes. Maybe somebody in the chat would be able to let me know why did we impound the sidebars? Why are those not public? Those should be public. You guys remember that was like the whole excitement from Dep v. Heard when we were waiting for those transcripts to be prepared while the appeal was pending, because the transcripts are public, and the transcripts are the full transcripts. They include the sidebars. Why? Why are we not seeing those? Is there a justification that we've been given? I don't know, but I don't like that. I don't care for that. So for whatever reason, we don't get to hear. We can't, like, if it has to do with the whole federal protective order, which I got some things I'm thinking about with that too. If it has to do with the federal protective order, surely you can redact. You can just redact some of that stuff. The entire sidebar conference is not going to be about federal materials. It may introduce, it may bring up, it may be necessitated by stuff that was in federal materials, but what's going on in trial in the courtroom is a legal proceeding. There's a necessity for a sidebar. There's going to be stuff in there that is not just recitation of stuff that was in federal materials. So at the very least, they could be redacted. And that would at least give us some context, some understanding of what's going on here. And particularly if we're talking about how the jury was supervised, who was in charge of that, details about how that was done, that has nothing to do. That has nothing to do with the federal investigation. That should not be off limits. That should be public. That's part of the trial process. So why didn't we redact them? I don't know. Apparently, this is another situation kind of like we saw in Delphi, where the media doesn't seem real interested in going to war on this one, which I just don't get. They got their big media associations. They'll file lawsuits when it's appropriate, when there's something going on. We've been watching that happen over in Coburger. The media's intervened quite a few times over court closures and cameras in the courtroom and so forth. Exhibits and trial testimony. These are things that there is very clear black letter law from the United States Supreme Court. This stuff is public. This stuff is public. So this is not a real gray area about maybe they can, maybe they can't. Okay, best case scenario is you can go in and you can redact this stuff that's relating to a protective order. But your obligation with public records is to disclose as much as you possibly can. So you minimize the stuff that can't be revealed. Media doesn't seem interested in fighting this fight, as far as I can tell. But unfortunately, that is starting to seem to be a little bit typical. I'm going to probably go on with Andy Kopsa later this week. If you haven't followed Andy's a journalist. She's gotten into the Delphi case. She's got a very interesting perspective on journalism and its intersection with the law and with legal reporting, which is, as you know, something I have criticized for quite a long time. There's a big reason why LawTube has become such a popular genre, and it's because we have been unable to rely on mainstream media sources to give us accurate information because they don't know what they're watching and they don't know what the significance of it is. But at the same time, the media has this incentive to preserve their exclusivity, right? That was what was so just cunning with how Judge Gull handled that triangulation in Delphi, where she created different rules for the credentialed media and preferred access and so forth, that she didn't grant to the public. And the media, from a constitutional standpoint, is no different from the rest of the public. They're no different. They're not special. But they're supposed to be there as our representatives. And yet, as long as they had their exclusivity, you know, the rest of the public rights, the rest of the First Amendment guarantee, it doesn't matter. So, yeah, they're not fighting that fight. They're not fighting that fight in Massachusetts over these sidebars for whatever reason. The federal investigation. Okay, we've heard this reporting, the second-hand, third-hand maybe reporting. Oh, the investigation's closed. It's done. They finished it. I'm skeptical. Guys, I'm very skeptical of that. Very skeptical of this information. And that's for a few reasons. First, we're coming up against this conflict between, normally the federal government doesn't talk about their investigations at all. They won't confirm, they won't deny. It's something that has the potential to tar people, you know, put a little bit of put them in a bad light, you know, if word gets out, they're under federal investigation, and you know, the investigation may not go anywhere. It may not produce any type of indictment, any kind of criminal process. And so, you know, once the bell has been rung, it's hard to unring that bell. If somebody's under suspicion and everybody knows they're under suspicion, then there's going to be a strong tendency in the public to look at that person side eye, even if they're never convicted or even charged of anything. So there's a very strong policy to keep investigations quiet. Now, that said, in their own policy, there is an exception for that. And there's actually a few exceptions, but one of those is something along the lines, I don't remember the exact words, but it's something along the lines of when the public has it's already become public knowledge, like widely disseminated in the public that this investigation is ongoing. Well, that really seems to be like what we're dealing with here. Everybody knows there's a federal investigation related to the Karen Read case. And we've seen the letters from Josh Levy. We know that they have a very different view of the events that took place January 28th to January 29th of 2022. Don't know who exactly their target was, don't know some of those details, but there's been a lot of speculation as a result of that. And so it's kind of in that situation now where more information would dispel some of that suspicion. And so I would expect you know, if they are going to invoke this part of the policy to actually talk about their investigation, they would do so publicly. They would do so directly themselves with a press release, which they do sometimes, with a press conference, a statement from somebody official, not just secondhand, third-hand leak to the press, leak to certain members of the press. So I'm suspicious that happened. You know, can't say it didn't, but I'm just not really buying into the credibility of that so far. The other reason why is because if the investigation is over, why would we still need a protective order in the federal court? The protective order is typically going to be there because it's protecting the investigative privilege. That's the ongoing investigation can be jeopardized if information is disclosed, if tactics are disclosed, if people see this is what the feds are doing, this is what they've been looking at, this is who they're talking to. You can make some inferences based on that about what their strategy is, what their thought process is, who might they go after next, what kind of information might they be looking for. And so the people who are under suspicion would then know what they need to know to potentially hide their wrongdoing. So you don't disclose the details of the investigation while it's ongoing so that you can protect its integrity. Well, if the investigation is no longer ongoing, that really doesn't apply. It doesn't apply anymore. Now, there's still going to be some other privileges that would apply. A very common one is the investigative tactics methods. You know, if they use some real common to use with informants, right? With your snitches. They don't want the world to know who their informants are. So that's like considered an investigative method, a tactic. And they don't have to disclose that even after the investigation is closed. But once again, we're now down to a much more limited scope of what needs to be kept private, what needs to not be subject to public disclosure. So you could go in and redact some of that stuff. If there's an informant, you can redact the informant's name. You can redact information that might reveal the identity of that person. Personal privacy, same thing. You know, yeah, the feds can get search warrants. They can get grand jury subpoenas. They can go and get a lot of evidence against people. A lot of that can be personal, but you can redact a lot of this personal stuff. So I'm just skeptical once again that this investigation is closed, because I would expect at the very least a relaxing, if not a total release of the federal protective order, and the extent to which the materials that they got that they've already produced to the defense, if not a total release of those restrictions, at least a relaxing of them in recognition of the fact that there's no longer an investigation to be jeopardized. So these things haven't happened. They haven't happened. There's no formal announcement. There's this leaking behind the scenes, which is just that's not credible. It's not credible. Okay. Sorry. But we've seen the kind of information that you get from anonymous law enforcement sources over in the Kohberger case. And they've had to go on record and specifically say a lot of this stuff is false. It's just false. And you know, it just muddies the water. You don't know what's reliable and what isn't. One of the best examples of that was right after Mr. Kohberger was arrested, and that video of him being stopped in Indiana. He was apparently stopped multiple times in Indiana while he was driving back to Pennsylvania from WSU for the Christmas break with his father. And there's body cam of the police officers. And an anonymous law enforcement source reported, and various media outlets ran with the story that the FBI had been tracking him. That this was, the FBI had gone to Indiana police and told them basically to pull him over. And that, it's because he was already on their radar. He was under constant surveillance. They were watching him all the way across the country. Well, we now know that that's not true. I mean, the FBI came out at the time and denied it, and they said that's not true. But it's already out there, right? And there's going to be some people that believe it. But now we know kind of for sure that it's not true, because he wasn't even on law enforcement's radar when that stop happened. Because they didn't even get his name until the investigative genetic genealogy came back. And that's in very late December. So they don't even, he's not on their radar. They're not tracking him from Washington back to Pennsylvania. They only know who he is for like a couple days before they go in and do the arrest, do the raid, and bring in the bear cat, pull him out of the house at 2 a.m. So, anonymous law enforcement sources, they don't have credibility. And, we, the public, can't vet them. So we're supposed to be relying on the media to vet it for us. And how well does that work? The media's got their incentive to believe it if they can, because they want a scoop. The media gets a scoop, they get an exclusive, they get this unique information. It's going to get a lot of hits. It's very prestigious. So they want it to be true. They want to verify it, whatever that means. They want to be able to verify it so that they can run with it. Well, does verifying it mean actually getting that information from another person, for example? Somebody official? Or is it more verification like, well, we'll just verify some kind of unrelated detail, like we can verify that this person is in fact in law enforcement? We can verify that, they said, maybe they told us that it went out by an email, and we can verify that is in fact their email address. This is where we have to trust the media. If they're verifying information, they're vetting the information for us, that they're actually doing it in a way that assures the accuracy of what they're reporting, and doesn't just give them an excuse to be able to check the box and say, oh, it's verified, so now we can report it, and now we can get our scoop. Now we can run with it. We can have the story that nobody else is able to cover. Probably some of the things I'll be talking about with Andy when we get a chance to do that. So then we were led to expect that at the last hearing, when Mr. Alessi was on fire, Mr. Alessi was on fire defending the defense team over the ARCA representations. We heard there was going to be an announcement there. It was going to come out. Yeah, that didn't happen. So there's been no confirmation, nothing official. So given that, no, I'm not buying yet. I'm not buying yet that the federal investigation is over with. But we'll see. Mr. Alessi is new since the last trial, since the last time I think I streamed anything on Karen Reed. What a lawyer. What a lawyer. that guy is a freaking powerhouse. That guy is he's so skilled. He's so talented. I'm incredibly impressed with him as an addition to the team. And word is he is pro bono. He just saw what was going on here in this trial, in this court, the allegations of misconduct on the part of law enforcement, what we've been able to see kind of with our own eyes. And just volunteered to step up and get involved. That's really impressive for somebody of that caliber. It looks like they are maybe getting ready to get going here. We're still looking at the fan over on Court TV. So is she calling us into session, or what's going on here?
You shall be heard. I'd say the Commonwealth of Massachusetts. This court is now open. You may be seated.
22-117, the Commonwealth versus Karen Reed. Can I also identify myself?
There you go.
Good morning, Your Honor. Robert Goffin for the Commonwealth.
And I guess I'm going to be over Judge Bev here. Put me down.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alleges from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Yes. So glad to see Mr. Alessi.
All right, so we've got a few things to cover today. We had a couple of questions to finish off about the defense position on the opposition to excluding the ARCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under dogger grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the tapes at the Canton Police Station video. So that's the order that makes sense to me, to finish up what we already had scheduled last week. You can look for anything else.
So maybe this is how we get out of the evidentiary hearing, is we're just so busy.
Before we start, so
maybe can't get to
I want
it.
to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You all know that. Do you understand that, Mr. Yannetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Alessi?
Yes, Your Honor.
So, each attorney is legally accountable for the actions and statements of the entire team. So, now the questions that I have, Mr. Alessi, that you said you welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you call it. Could you stand, please, because I need to
Yes, I was going to go to the podium.
Sure, go ahead.
Thank you. I didn't want to stand where you were talking.
You could stand. All right, so the pause email, as you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. And we'll get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between Arthur and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring, or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
I am inferring, Your Honor. I do not know that as a fact.
Okay. So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time?
Same time as what, Your Honor?
As the invoice?
And you're referring to the record of payment being...
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, on the weekend, February 16th. In the Commonwealth's opposition, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that?
I
had to
Context?
ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just wanted to make sure you were finished with your
Go ahead.
question. I learned that that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned...
You don't have to
I'm sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to... So I'm answering your question.
Well, yes and no.
That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the answer is, Your Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through, and when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes, it was paid. And I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA It's signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it. Is in order to violate 3.3A1, the attorney in question has to know with regard to the fact and issue.
Can't
so
impute it.
Respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But, Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. In something that critical of candor to the court, that's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly participate. So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with Your Honor.
That's right. Yeah, he's right.
I'm not going to ask other counsel. All right.
Well, why don't
so
you?
Let's move on to the next motion.
Your Honor, if I could,
Do you want the answer or not, or was this all for the cameras?
And I had marked Mr. Brennan has agreed to them going. May I just offer them in at this time? They're all marked. There are two. Your Honor's February 6th was Exhibit 1, so I picked off on 2 and worked it out before. What would you like me to do with these, Your Honor?
You can hand them to the court officer who will hand them to.
Well, there you are. Thank you. Thank you, Your Honor. And have you concluded what you?
Yes, but let's take this one.
Okay.
So she doesn't even want the answer. She won't even ask the attorneys. Did you know? Did you know?
So
Did
let's
you
go
know?
on to did the Commonwealth want to add anything?
No, thank you, Your Honor.
So she's not going to find them in contempt. She
So
can't.
let's
She
go
doesn't
on
have the
to-
record for it.
Don't-
Talk about all for the cameras.
So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby. And I've read it. I read it 2 weeks ago when it came in, Mr. Leslie. I'll hear you on your motion.
Thank you, Your Honor. I'm just getting myself reoriented
Take your
back to.
time.
Thank you.
So Crosby is the vet, or is Crosby the weather guy, or is Crosby the dog guy? Crosby's the dog guy, right? He's the dog trainer. Yeah, Crosby's the dog trainer. He's the one that is going to say, he wants to say that's not a dog bite, but he's not a medical expert. His testimony is about like the aggressiveness of dogs, the rehabilitation factor of dogs based on how hard they bite, stuff like that.
Entire proposed testimony of Dr. Crosby should be excluded because he is plainly not qualified to render the opinions that he is trying to render.
Yeah.
And his methodology not only is not reliable, but it's not even documented. Your Honor well knows the inquiry under Dalbert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do, and I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements, so it's very clear that's the subject matter of his testimony. Your Honor stated, with regard to Dr. Rentschler, that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Point. Only an MD can do that. That's what Your Honor said was the clear
Yes,
law
she did.
in Massachusetts. Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not a veterinarian, he's not a forensic odontologist, and those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established by saying, well, you know, this case is not about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm, and yeah, you have to be a medical doctor.
Nobody treated the wounds. He was dead.
So I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor.
Touchy.
With
He's
regard
touchy.
to his area of expertise, it can't be more obvious than his own proclamations. He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is what he is expert in. And of course, there's no issue whatsoever in this case about canine behavior. And more importantly, his own report doesn't discuss canine behavior at all. So in conclusion, on the qualifications prong, Your Honor, based upon Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further than the qualifications prong to exclude all of his testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense that when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor, with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially, he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's no
Purported Chloe.
documentation of that. But let's assume, hypothetically, it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, and then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog, and this dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object. It just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially
a differential
another
diagnosis.
diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons.
Because it's ridiculous.
First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ABFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted.
How
He
you could
doesn't
extrapolate.
cite to one study, he doesn't cite to one scientific publication that says this is a permissible way to determine whether a bite is from a dog. So the burden, as Your Honor knows, is on the Commonwealth to establish the methodology. And I note, Your Honor, that the Commonwealth, in its first response, states in the third paragraph, Dr. Crosby engaged in recognized methodology to study the abrasions on John O'Keefe's arm.
Did he? Should we talk about misrepresentations by the
What
Commonwealth?
methodology? Where is it? It's not in his report, and it's not even in the opposition. So they try to brush over with a conclusory statement, Dr. Crosby engaged in recognized methodology, when it's nowhere in their opposition. Where's the recognition for it? That dooms completely their second prong of Daubert. Then what they say about methodology in the same paragraph, they say the methodology employed was based on facts, science, and study. What do they cite to?
Oh,
They
my
cite
Lord.
back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. And this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was, for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse
Science.
for the Commonwealth, Your Honor, on
Science
the methodology.
is the basis.
Because
How bad a tell
there
is that?
are potentially some methodologies that might be used, they're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission, the Commonwealth put in, very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that, and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition, and I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound, and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists. And even then, the science is very questionable.
Indeed it is.
What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the wound. 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in a defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine, but the fact is her main point is he never accounted for that in his methodology. It's not an opinion, it's a methodology. So, again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support. But he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained, they have to give a fair and accurate depiction, and you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My. She had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin, human skin, when there's any pressure, particularly with a bite. It moves, it tingles, it hits the muscles, etc., etc. He gave no account for the condition of the human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So, with regard to the Commonwealth's response, I'm appreciative of the fact that they cited to his thesis. So what they say is, in the second paragraph, they said his master's thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer-reviewed. So what did I do? I went and read both of his theses.
Of course you did.
What I found is particularly probative of the issues I just raised. So I looked at his and read I read 179 pages of his 2016 Master of Science thesis that they cited.
But they didn't read all 179 pages.
He talks about, on page 46,
Oh my
defining
Lord.
bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate in his thesis that he confirms Dr. Russell's methodology. What he doesn't do in his thesis is even mention his own methodology that he used here. In 179 pages, there is not one reference to the methodology he used in his report. With regard to, I mentioned the ABFO, the American Board of Forensic Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. there is no science on the reproducibility of the different methods of analysis that lead to conclusions about the probability of a match. A very, very, and I couldn't agree with Dr. Crosby more on that. He then talks about, in his thesis, about the fact that there's no accepted methodology for dog bites, even using ABFO. And on page 63, I'm going to quote what he says. Although the ABFO does not specifically address animal bites, it would be logical to apply the same standards to forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that you just, even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition, Your Honor, he never worked with a medical examiner for his methodology. He never worked with a forensic odontologist. In the case law that we point out, even in this very suspect area of bite mark analysis, even in the cases that allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his
other
PhD thesis, which is more recent, 2023, maybe in that thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities, a Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods and reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior. Second sentence, page 63. Classifying dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective.
From the dog's perspective.
That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point of needing a medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. He's certainly not a veterinarian, although if one reads it quickly, one might think that's what it issued. He's not. He was a police officer for 22 years. And even then, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, if they're aggressive, etc., etc. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications to do that. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell and her ability to testify. If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby.
It is very easy
So I
call.
respectfully request that he be excluded. There's no need for a Daubert hearing. It's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the deceased.
It would be misleading.
Very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object, is he? Are you planning on bringing that in?
I wouldn't ask him to do that, no.
All right, so I'm going to
Yeah?
yes.
All right, so already one on that.
Mr. Releasy tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts. One difference is that Dr. Crosby has actually testified in state and federal courts regarding dog bites before, where Dr.
Regarding
Russell
dog
never
bites.
had before this case. And so, in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. And that was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Releasy's opinion. In addition, Dr. Crosby set out
That is such a bullshit
in his
argument.
package
What did he
numerous
testify about? What was the
different journals and
subject
publications
that he was qualified for?
he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive: variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Lisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor. There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he has, and I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the exhibits that I have are attached to the Commonwealth's, the defendant's motion?
They
So
have-
I don't know that I have all the reports.
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification that it was in fact Chloe, has the Commonwealth provided that information to the defense?
We have, and we can provide that as a supplement to the court, the verification of Chloe, and we can also provide to the court the bite mold analysis report of Dr. Crosby, which is not in this package.
I think that's attached here. I have the photographs.
That's part of the original report, but then he actually took a mold of Chloe's jaw and teeth, and then I asked him to supplement the report regarding the mold.
And that's been provided to the defense?
It has, but it has not been provided in this package, so I can provide that to the court. So I'll supplement those two different items for the court's reference. In addition to his experience, he was Chief of Animal Care Protective Services of the City of Jacksonville. He had oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate canine brain project, 2023 to current. It's associated with Harvard University.
None of this
Duties
relates
include
to the subject of the
investigation and
testimony
documentation
that
of
you want to
dog bites and
proffer.
related human fatalities. Also, Division Management Consultant for Animal Care and Protective Services, City of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now, in Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. So when we compare, I'll refrain from getting into too much of a comparison, when we see the actual study of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time. You can see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which he used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, and scissors.
Look, there are
And then
pictures. You must let it in.
that
Oh,
he has
my
measured
Lord.
the distance of all of those teeth, specifically. And then in his methodology, he outlines each group of lesions, specifically lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth.
Totally dissimilar.
He does look, as Mr. Alisi suggested, at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA, significant to Dr. Crosby because in virtually every case, he finds canine DNA. So he does look to alternative sources. And mindful, there was pig DNA found, so it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence.
So how does he explain?
that
Did a
there is
sharp
no
pig cause the
animal
injuries?
DNA.
A very sharp
And
pig.
so, while there are different methods, and some of the things that Attorney Alisi spoke about, dentition, deal with human biting, not dog biting, his methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case. He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based, not on hypothetical or rhetoric, but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered, and he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?
Absolutely not.
Okay. All right, Mr. Leslie, any follow-up?
Thank you, Your Honor. Thank you.
Oh, what a train wreck that was. He has to rely
Commonwealth did
on
not
generalities.
address in its presentation, you heard one probative, legal, or factual point I made because they can't. Specifically, the Commonwealth just stated that Dr. Crosby has testified in court numerous times. On what?
Yes.
It's important. You can be qualified to testify, and if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog? I get it, but the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. It wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human was from a dog or a specific dog. Point number 2. Mr. Brennan mentioned he cited numerous journals. Your Honor, I would ask the court to take a look at his report. There is now...
Hold on, so that's
Yes.
exhibit 1.
Yes, exactly.
Just give me a minute. Just put them back together. All right, so what page?
Every page. The point is, there's not one footnote in any of his reports. So he does go through his purported methodology. I've never said he didn't present a methodology. My point is, his methodology is not accepted, let alone generally accepted, and nowhere in his report does he say this methodology, this measurement methodology, is accepted at all. And you have to either show in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites to numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
Okay?
So he's got it in alphabetical order. Importantly, the page before, 1399, at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case. You can't have an expert report that
Here's books about the topic.
Dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did.
Yeah.
And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't because he can't, because his methodology, to the best of my research and Dr. Russell's, has never been accepted by anyone. So then what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is, because he's participated in autopsies, he must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and, for whatever reason, immediately truncated it. I will just reference that book is not peer-reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Dalbert, you gotta have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior?
He's being
In
vague
Dalbert,
on
it's
purpose.
The subject matter, the testimony, which is what's the medical cause of the wounds to right arm.
Yes.
That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard. But what is it that he is participating in Harvard in? And this was from the words of Mr. Brennan. Canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of wounds to humans and whether they're not from a dog. Mr. Brennan said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on a reliable methodology. Facts, yeah, they are somewhat relevant, but the most probative aspect is methodology. So I am still, after all this time we've argued this, waiting to see where is the study, where is the documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly criticized, where is that methodology documented in one of these many references at the end, no footnotes in his study? I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home.
It's a sad
because it's
little
not
orphan.
generally accepted. So he is not qualified under Daubert-Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to whether the cause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that his methodology is reliable for all the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance, and Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Anything else, Mr. Brennan?
Briefly.
He gets another bite.
On page 6 and 7, Dr. Crosby offers court cases in which he has testified or provided expert opinion. I will give you specific cases where he's been qualified in state and federal court. Mr.
Qualified
Lisi harps on the
for
idea of
what?
methodology. If we remember Dr. Russell's testimony, it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis. And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis. Attorney Lisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report. And when you look at Dr. Russell's
Jesus.
affidavit in support, there's something, to be intellectually honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter if somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been
Well, then
accepted
provide
by
the
courts before.
information.
Thank you.
You had multiple opportunities to do that. Oh,
So
man.
before we move on to
Weak.
the next motion, the next motion was, it was filed after the other motions that we finished here. It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative of Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think it had just been filed. So I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you. Mr. Leslie, this is you again, right?
It is, Your Honor.
All right, so I'll hear you. And this is paper 515.
May it please the court, Mr. Gilman, a meteorologist,
The
was
weatherman.
attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation, but what we do challenge is his opinion with regard to the hardness of the ground.
Rock hard. It would have been rock hard.
With regard to his qualifications, his qualification to opine on the hardness of the ground. He is not a geologist. He's not a pedologist, i.e. a soil scientist. There's a specific field for that.
Yes, it is.
He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes.
Irony quotes.
So his certified weather statement is hard as a rock, I believe. I'm looking
is.
for it.
So I'm sorry, would I have, there were a couple of exhibits attached to your affidavit, Mr. Leslie?
Yes.
All right, so one's exhibit 1, I don't see any.
I'm sorry, Your Honor, it's Exhibit 1.
Okay.
It's his February 3rd, 2025, quote, certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes, the
Okay, I see it. All right. I don't see anything that says certified weather statement.
Hard as which rock? Talc, maybe? Is it hard as talc?
his report is Exhibit 1. It does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology.
How about a replicable standard?
And that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And, Your Honor, there is a deep and typical of science, complex way to determine hardness of ground.
Yes.
And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use its, not it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees, below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I've never heard it. Because that's not what meteorologists do. So I believe in terms of common sense, in addition to the other arguments, I think common sense just tells one that this is not the kin of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using layman like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever, but that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Dalbert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
No, he definitely shouldn't. I mean, it's just beyond ridiculous.
First question, do you intend to call this witness in your case in chief or for rebuttal?
I do, case in chief.
All right, over you.
Thank you. The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed. Talk about
Because
the
we didn't
temperatures,
have enough on
the
video.
wind conditions, also the snowfall.
The shoveling the
Seems
apron.
that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground is hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock.
That would be a problem
We
because
have
that
a
would be
handful of
suggestive.
First responders who will give lay opinions with common sense that the ground was hard as a rock, and state police who excavated can testify to that very thing. So Mr. Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Would you say that, Mr. Lessons?
In specific answer to your question, Your Honor, what do I respond to that? I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic.
Yep. So you're going to use a
Because-
simultaneous heat and water model?
Just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G., 2005, freeze-thaw effects on penetrometer resistance and shear strength of...
Why don't you put those in writing? Was that just a Google search? I saw that you had it on your...
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Is it a Google search? No.
Is there any objection to the Commonwealth to me getting that?
Not at all.
The National
You
Academy
wanna
of
provide a
Science's
copy to
head.
Commonwealth as well?
I'd be pleased to provide a copy of the Commonwealth.
All right, so I'll take this under advisement.
Ooh.
So how long do each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, or the cases and the qualifications of Dr. Crosby?
I can have that to you today.
Great, okay. And those articles, Mr. Alessi, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just give me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
You let me hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Alessi? Did co-counsel have copies?
Oh, no, the co-counsel doesn't have any of this, Your Honor.
Okay.
I just need to black out something here that's...
Sure. You don't have to do it right now. Do it before you leave.
I'll do it before I leave, Your Honor.
Now
Thank
we're
you.
there, we'll see to it. Jim, can you get a copy made for everybody? Thank you. All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions. And this involves a transcript that I've read. I've listened to the actual recording. Maybe it makes sense to take a 15, 20-minute recess. Now, does that make sense to everyone? Okay.
All rise for the pledge,
Is
please.
the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just the transcript? Actually, I'm going to see Councilman.
You may be seated.
So it's fan time. Well, I don't know if they're going to come back on, so I guess I'll just leave this on in the background for now while we get our recess. Oh my Lord, that was a slaughter. That was an absolute slaughter. I just am more and more impressed with Mr. Alessi every single time he gets up and talks. This guy is so on point. He's so on point. He's so methodical. He's so meticulous. And he is really lethal when he is pointing out very systematically what his argument is, and then that doesn't get responded to, you're not gonna sneak that past him. He's gonna notice. He's got that kind of brain that is gonna spot you didn't actually respond to the point that I made, and he's going to be able to nail you with that. It's clear that Dr. Crosby, he's not, they haven't shown that he's qualified to testify about the cause of a dog bite, or the cause of an injury being a dog bite. And the only way they can even imply that he is by relying on these generalities, that he's testified about something, that he's written books about something, therefore he's an expert in something. That doesn't mean he's an expert in anything and everything you want to put his opinion. Like it's very transparent that that's what the problem is. He's got to have the specific qualification to justify the testimony, the specific testimony that he's being asked to give. Not is he generally qualified as some kind of expert in something. And so, I mean, I think that Mr. Alessi just absolutely murdered his qualifications. Oh my God, he read his theses. He read both of his theses. I mean, and then turned it against him. This guy is so sharp. This guy is so sharp. I you know, I don't want to put too much of a burden on him if he is the pro bono guy, and there's obviously, you know, a whole defense team that has been in place before him that is continuing to participate in this case. You know, unless Bev kicks him off, I don't know. We're still waiting to see what's going to happen with that. But I want to see him play a much, much bigger role in this retrial, because his skills are just so top notch. He's so likable. I mean, the way he is able to deliver that knockdown punch with humor. I mean, it's just hilarious. I've never heard the weatherman get up and say today will be winds from south-southwest at 9 miles per hour and intermittent clouds, but mostly sunny, and the ground will be hard as a rock. And I mean, that just it makes the point, doesn't it? It makes the point. You know, you're right. You don't ever hear a meteorologist say anything like that. And it's such a ridiculous argument. Anyway, the ground is hard as a rock. The defense has a medical examiner on their expert list, Dr. Russell. Dr. Scorty Bello is going to testify again too. She wasn't really all that helpful to the Commonwealth the first time, right? Had to acknowledge, yeah, these are really not conventional traffic collision injuries, pedestrian vehicle injuries, not what you normally see from that type of interaction. What's she going to have to say about could ground dirt with grass and some snow on it? Is that what caused the skull fractures and the 2-inch laceration to the back of John O'Keefe's head that, by the way, doesn't appear to have bled anywhere? It doesn't appear to have bled anywhere. That's kind of a mixed bag. It's a mixed bag. I mentioned this on Twitter. Certainly not an expert in this myself, but I'm aware that it's a science. I'm aware that soil science is a thing. Why? Because I frickin' garden. And it's kind of important to know about how ground freezes, when it freezes, the depth of how it freezes and stuff. Kind of important to know that type of thing when you're trying to grow stuff. And so it plays a massive role in agriculture. And one of the big reasons why is because a lot of crop pests will overwinter in the ground, and then just as the soil warms. So now are we having our break? Yes, now we're having our break. So then as the soil warms is when the insects will emerge. And it's a very, very important thing to know in agriculture, because that's what determines when you need to apply your sprays. I don't spray in my garden. I've been through and done that before. It's like a holocaust using some of these stuff. Some of these chemicals like the organophosphates and stuff, they just kill everything. So it's not my thing. I like butterflies. I like bees. I like having beneficial insects around. So as a result, I have to do much more labor intensive and annoying things like bag my apples by hand. But the point being, these how the ground freezes and thaws and how that relates to the external weather. This is literally something that any orchardist is going to do, because you count your frost days, and based on that, they can kind of shorthand. This many consecutive days at or below this temperature is how the ground temperature changes, because there's a lot of variables. There's a lot of variables in that. When the ground freezes, okay, when water freezes, water releases energy when it freezes. So there's this phenomenon where as the ground starts to freeze, the surface of the ground will actually get warmer, because that release of energy from the water freezing, just a, chemical, physical thing that happens, will accumulate, will cause the surface to become slightly warmer. So there's all these kinds of variables involved, and those all get factored into these sort of shorthand formulas that farmers and orchardists will use. Okay, after this many days, the ground temperature will reach, this point under these conditions. And that's important, because that's what tells me that's when the codling moth is going to emerge. And once the codling moth emerges, that's how I got to time my spray, because these pests go through, codling moth, it's like 3 or 4, maybe 5 life cycles over the course of a growing season. If it's already deposited the eggs, it's too late. You got to get it while it's a moth out there before it inflicts all its damage on your crop. So you got to time it. So they need to know these things very specifically. So all these shorthand methods have developed by applying very specific sciences, and the one that I'm pretty confident Mr. Alessi is referring to here is this technical method is the simultaneous heat and water method, and it's like I think there's like 9 variables that go in that you have to enter, and just what has the temperature been lately is just one of those. The soil type matters, the drainage matters. The hydrology matters, like where's the water table, how saturated is this soil, like all of these things are going to make a big difference. So hard as a rock, really. That's what we're going for now. The reason I got down this tangent is because, when the ground is frozen, what it doesn't do? It doesn't absorb liquid. It's frozen. It's now an impermeable surface. So where's all the blood? The only explanation really for where the blood could be is that, well, it seeped into the ground. It just became mud. And that's why it's not on John. That's why it's not on any of the snow. When we're going through and shoveling up where he was, there's no puddle. There's no nothing where like the snow hit the blood and then froze. There's absolutely nothing like that. Where's the blood? Where's the blood? We know with our common sense how much a 2-inch laceration on the back of your head is going to bleed. Okay? It's going to be a massive puddle. It's going to be all over the back of your head. Your hair is going to be matted. It's going to be all over the back of your clothing. And there isn't any of that. We've already seen the evidence. There isn't any of that. There's no blood on John's back, on his clothes. No, where's the blood? The blood is dripping down the front of his shirt, the front of his pants, and the top of his shoes. Just like it does when you get in a fight. Just like it does when you get in a fight. And your nose starts bleeding. You get opened up on the front. What does it do? It drips right down because that's how gravity works. So when did he get back on his feet? After the hard as a rock ground fractured his skull and caused that laceration? When did he get back on his feet for the blood to drip down his face, down the front of his clothes, and somehow not drip down his back? So one of the reasons why I really want Mr. Alessi to play a bigger role in this trial is because that's where the Commonwealth's theory of how this accident happened, that's where it all falls apart, is in the details and how those details line up with the physical evidence. And Mr. Alessi is such a master with the details. He's so good with them. He spots them and he's able to articulate them and point them out in a very simple and understandable way, and in a humorous way, in a way that really makes you laugh. Weatherman doesn't tell you, by the way, the ground's going to be hard as a rock today. So right on the attack from the get-go, Judge Bev, right on the old attack to the defense, trying to get them to concede out of the standard for contempt, trying to get a concession from them that they can be in contempt without knowingly making a false statement of fact. You're all responsible for what everybody else says. Well, I mean, maybe in terms of needing to correct it when it comes to their attention, or needing to clarify the record, or whatever, which seems to me they have done. The worst thing that I've seen in all of this whole issue with the contempt and them allegedly making these misrepresentations and the candor to the court and so forth, is that sentence in the memorandum that she pointed out today, the February 16th memorandum, where they said, the defense didn't pay for ARCA. And they've since clarified it. They've since published a supplemental affidavit from Ms. Little explaining the total circumstances, which they had already, as we learned, fully disclosed to the Commonwealth. And so that's really the worst, I think, sentence that they have, because the rest of them, they're not false. The issue at the side, there's apparently a sidebar, and Mr. Jackson had said, well, the defense didn't hire ARCA. That's true. That's true. They didn't hire ARCA. They didn't hire ARCA to do the work. They didn't hire ARCA to do the opinions, and they didn't hire ARCA to testify. They subpoenaed ARCA to testify. They subpoenaed them. So that's not a false statement that they didn't hire ARCA. So the only thing they have is this line from the February 16th memorandum that they didn't pay for ARCA. Is that untrue? They didn't pay for ARCA's work. They didn't pay for the reconstruction. They paid for their travel and their time, according to the revised affidavit. So, could have been clearer, definitely could have been clearer. But we got to kind of consider the context of what we're talking about here too. Because the whole reason any of this came about is because the Commonwealth is challenging ARCA on the basis of the substance of their testimony and what's available and when it's discovered and who has access to it. It's the same issue that they litigated before the first trial, where the Commonwealth says, we want this information, and the defense says, yeah, we want it too, but we can't have it. None of us can have it because it's subject to this federal order, this federal restriction. And ARCA has been told they're not to communicate with us. So they both get ARCA's report shortly before trial. Report details the work they did, the opinions that they were going to testify to. That's all elicited at trial. The information is all equally available to both of them, and there's no dispute that none of that was initiated by the defense. It was the feds that hired ARCA to do all of this. It was the feds that defined the scope of the work. It was the feds who paid them to get their opinions about whether the injuries to John and the damage to the vehicle were consistent with this pedestrian vehicle collision that the Commonwealth is asserting as the cause of John O'Keefe's death. So there's no dispute at all that the defense did not hire them to do that and did not pay them to do that. And that's what the motion was about. So, this is, from my perspective, certainly not ideal from the defense team. Would it have been better to be more specific? I suppose so. But was it it wasn't relevant. It wasn't relevant to the issues that were in front of the court. Because the Commonwealth wasn't saying anything like they shouldn't be allowed to testify in the new trial because the defense has since paid them for their testimony. That's something that the Commonwealth can raise in the retrial if they want to do that. If they want to try to argue that ARCA is biased because the defense paid them $23,000 in July after they testified, they can bring that up. And you know what that's going to do? That's going to open the door for the defense to put that in perspective, to put that in context. What was their total bill? What was their total bill? We'd love to know, because it was not cheap. It was not cheap for ARCA to build a cannon, to build a shot glass cannon. I know it wasn't a shot glass. It's more of like a rocks glass, a tumbler. To build a rocks glass cannon and fire it at a bunch of cars, at the taillight of a bunch of cars, and see what happens and document all that. Like, no, that's not cheap. That's not cheap. What was the total amount? And so what percentage of all of that does the amount that the defense paid reflect? Clarify the defense didn't hire them to do any of this work. We already know that. They testified to that in the first trial. But, that the defense didn't pay them. So what, in fact, did the defense pay them for? The defense paid them for testimony in a prior proceeding where the Commonwealth didn't meet its burden of proof to convict Karen Reed? You really want to open the door to that? You really want to open the door to that? Because I kind of feel like that's going to be on the table. That's going to be fair game. You couldn't convict her once, so you're trying again. And we paid them before to come in and testify about the work that they did for somebody else. And now we're doing it again. Does that help? Does that help the Commonwealth? Or does it just make it look like, maybe they're dug in? Maybe this is kind of a waste of time and money, especially as the jury is hearing more and more of the details about the Commonwealth's theory. Are we going to get Trooper Paul again? Is the jury going to have to sit there and listen to Trooper Paul and be like, you're prosecuting her a second time based on this? Based on this nonsense? So the Commonwealth has the information now. They can use it if they want, but it's a little bit of a be careful what you wish for kind of situation. I wouldn't be surprised at all if they don't mention that. Don't open that door, because I don't think you're going to like where it's going to go. So it's minimal from my perspective. To the extent it is a misrepresentation, it is a de minimis one, and it's one that is understandable given the context and what was actually under discussion and what was actually relevant for the issues that the court's being asked to consider. So but now let's hold that up next to the Commonwealth and the Commonwealth shenanigans. You want to talk about misrepresentations? Yeah, let's get back to that video. Let's get back to that video. Can't help but notice, is that going to be how Judge Bev gets us out of having the evidentiary hearing? There's just not time. So many things on the plate, and we've put that motion for sanction, that motion for the amend the scheduling order. That's way down. That's way down. We're going to hear Gilman first, and we're going to hear the Commonwealth's motion. Well, we heard Gilman. We're going to hear the Commonwealth's motion for sanctions. She's going to probably jump to the reconsidering the prior ruling about the metadata, about she said the Commonwealth doesn't have to produce the metadata because she doesn't have any testimony that it's necessary. Okay, so now the defense has submitted an affidavit from a computer forensic expert saying you need it, and here's how you need to do it, and what they're proposing to do is not going to achieve that. We're going to hear all this stuff first before we get to the motion to dismiss. We know she really wants this trial to go forward on April 1st. And I'm sure we've all got our theories about why that is. You want to get it done before Memorial Day weekend, right? Summer starts happening, and everyone's got better things to do in their beach houses over the summer. But they got a lot going on, and they got a lot to resolve, and we don't even have motions in limine yet. I think they were supposed to be filed yesterday, right? But I didn't see any of them come through. Maybe they've started to come out today. There's probably going to be more. All these motions that she's now taking under advisement with the Commonwealth's experts, I don't see a way she gets to yes, they can come in without at least having the Daubert-Lanigan hearing, because they've got to clarify. They didn't put any of this stuff in any of their response. The Commonwealth, as far as showing me that this is a reliable, scientific, acceptable, based on valid principles and application, replicable, etc. You know, the Daubert standard, or that this is something that experts agree you can do this reliably and accurately, and it will give you a good result. So they haven't met that initial burden. So the only way I think she gets to being able to establish that they can use some of this, she's got to have the hearing. They got to bring the expert in to try to justify, this is why I did it this way. This is why I think this is the product of valid scientific principles and it would be replicable, and et cetera, et cetera. That's going to take time. Took them 2 days to get through Dr. Russell. So that's going to take some time. If they want to try to do this with Dr. Crosby, it's going to take some time. They don't really have that time set out. What's our schedule so far? We got another day tomorrow, assuming that we need it. We got another day tomorrow. We've got Friday is the final pretrial conference. We've got 2 days set out for motions in limine in like 2 weeks, and then we got the trial, and that's the time that's set out. So I don't know where they're going to cram in if they want to go down that road, where they would try to cram in evidentiary hearings on a Daubert-Lanigan issue. It just seems like a problem. So she can dismiss it outright, grant the motion, exclude the expert. That would be the right ruling from my perspective, because they haven't even met that initial burden of suggesting that they can meet the Daubert-Lanigan standard. But if she wanted to bend over backwards and give them the benefit of the doubt, she'd give them an opportunity to have a hearing and establish that. But when are they going to do that? She really doesn't want to move the trial. And the ostensible reason for that is because of the speedy trial limitation. Well, the speedy trial limitation under the Massachusetts rule is 1 year from the date of the incident that occasioned the retrial. And so normally they're talking about an appeal. They're talking about the case goes up, it gets reversed, it gets sent back down. And so you have 1 year from the time the Court of Appeal reversed it, and that reversal becomes final to do the retrial. It's not our situation here. We didn't get a reversal on appeal. We got a mistrial because we had a hung jury, which of course is still now pending in the federal court. Whole other complication. So it's going to be most likely a year from the mistrial. The mistrial is the incident, the action that occasioned the need for the retrial. But I could see an argument that maybe it's the hearing afterwards. You know, I don't know. But that was in April. That was in April. I mean, even under that calculation, we still have some time. Looks like we're back.
All right, so the next motion we have is the Commonwealth's motion to impose sanctions pursuant to Master Criminal Procedure 48. Mr. Leslie, do you need a minute? Did you need a minute or so?
Could I please just?
Sure.
Thank you.
Jimmy?
Yes, I'm working on something.
Working on something.
Why don't I take a 5 minutes?
All right, please.
So 5 more minutes. Back to the fan we go. Well, so I'll just finish my train of thought then. What I was saying is that even under the 1 year limitation, if we took a hard limit on date of the mistrial, and then 1 year from that, we still have until what, well into May. I don't remember the exact day that the jury came back, but we're into May. So we got more time. We could kick this down the road. But the rules also got exceptions to it. And included are the exceptions are periods of delay that are necessitated by pretrial motions. So if you need more time to litigate this stuff, that gets excluded from the time period that that you're having to calculate for your 1 year, your 1 year speedy trial limit. There's also an exception for interlocutory appeal. Habeas petition isn't exactly an interlocutory appeal, but it's pretty much the equivalent in this particular context, because it is happening on an interlocutory basis. It is going to a higher court for review, and it does have the potential to determine whether there's a trial here at all. I guess the argument on that is on Wednesday. That's going to be in federal court, so we won't be able to live stream it. We won't be able to see it. We'll be dependent on folks in the courtroom to tell us what's happening. I just am crossing my fingers and really hoping that there is going to be somebody in that courtroom with a legal degree, a legal education and background, who can understand the significance of what's happening. Habeas is technical stuff. Oh man, habeas corpus is technical stuff, and the legal issues that are at stake, they are technical legal issues. I've said before, I predicted the ruling from the Indiana Supreme Court. I knew that was going to happen. The law is not favorable to Karen Reed on this issue. It's not favorable. And it's really not much more favorable on the federal level. The Bluford versus Arkansas case is a big problem. It's a big problem. That was a case where the jury, it has to do basically with a partial verdict, and the jury had reached. Here we go.
Sure. All right. So, Mr. Brennan, I will hear you on this motion.
Thank you. As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred.
Sacred.
There's no need for protective order. There wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation, because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, given the history of this case, it is important to make sure that these type of violations don't happen again.
Yeah, like maybe you shouldn't mention fanning in the sidebar stuff.
As a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness,
His absolutism is so unpersuasive.
didn't want to watch a closing, there is no good faith basis whatsoever that that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information of the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court, it's unfair to the people of the Commonwealth, it's unfair to the Commonwealth, it's unfair to the prospective jurors. And so, not only is there not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We turned it over as a text message, and notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57, and again, there was a protective order, and then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case.
Shall we consider the cleanliness of the hands of the Commonwealth?
Or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours, it was within 24 hours, this was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community.
Oh, kind of like how the federal investigation is over? Got spit out and everywhere?
There needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements, and despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter.
Mm-hmm. Yeah, and then let's look at the RPC 3.6 case law, shall we?
The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I...
You can actually. The rule specifically says you have a right of response.
My obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of
So here you are
involvement by
putting it
everyone.
all in the public record less than a month
Specifically,
before
3.6 is
trial.
particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses.
Well, it's technically the defense theory of the
There's
case.
been a ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign.
Evergreen recommendation right here.
In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response.
Thanks
by the
for
U.S.
reviving
Attorney's
that
Office
more than a year
after
later.
they implied.
Where was that made?
Let's make sure the public knows that a month before trial.
Comment that you just said, where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on court TV with Miss Reed. The Commonwealth is moving for a protective
Is that where he
order
made the
for these
statements?
letters after revealing
Because
part
that's
of
a
what they
slippery
contain.
answer.
The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is,
Where was that court TV again?
I can get the date for your honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion.
So she made an argument
And
in
this was
court.
a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal
here we have it.
investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that.
Yes, they
If
are
there's
in
any
fact
doubt
going to defend
whatsoever
their
about the
clients
intentions
in court.
of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules.
Or
What I
will you?
suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them. And
Yeah,
make
let's
any
talk about the
objections if there's any material
First Amendment
that's private,
implications
so
of
that
that.
there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does.
Make your complaint to the
No
bar if you think there's a
symposiums on the
3.6
courthouse
problem.
stairs.
That's their purview.
No more interviews with national media. No more statements to press privately behind the scenes over a coffee.
That's going to be a First Amendment limit.
Information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact. There should be a gag order on all of these attorneys, every single one of them. And the Commonwealth will not speak either.
Oh, out of the
Ms. Reed,
goodness
I'm
of
not
its
asking
heart.
for a gag order for. And so in light of the history of these repeated violations, in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this case, is to impose those sanctions, and that's what I'm asking for. Thank you.
Mr. Nitty, you're arguing this, you said?
Yes, Your Honor, may we approach, please?
Okay.
Little sidebar first. Interesting. Yeah, so, I mean, what Mr. Alessi is asking for here is directly contrary to Gentile versus State of Nevada. That's the U.S. Supreme Court case that considers the fact that attorneys also have First Amendment rights. And so these ethical rules that restrict the attorney's ability to make public statements about their cases, it's got to be very limited to simply addressing the concern that attorneys can potentially taint the jury pool, that they can, their opinions carry undue weight and things like that. So, you know, a flat out gag order, they can't speak. No, that's not going to be constitutional. That's going to be a problem. And you know what, Judge Bev, if you grant that order, there's going to be another interlocutory appeal, or at least there should be. And it's going to be one more thing that is going to be on the table before the trial can go forward. And then when you try to conflate the public statements that RPC 3.6 is dealing with their litigation of their case in court, their presentation of the defense, yeah, that's going to be a little bit of a problem too, because they also have to kind of do that. That's kind of Karen Reed's Sixth Amendment right there. To be able to litigate issues and present a theory of the case that just because you think they're wrong, you sure want the jury to believe they're wrong, doesn't mean it's factual. Just because you say these are hardworking, ethical public servants, well, we've seen with our own eyes who they are and what they do and why they spend a significant amount more time and effort investigating Turtle Boy and people who leave ducks on the sidewalk than they do the death of a Boston police officer. We've seen all that. Yeah, just because you say they're dedicated and hardworking doesn't mean that that's a fact. that they're then somehow misrepresenting by having a theory that these guys are acting dirty and that there's a lot of stuff in this case that's real sus, that doesn't smell good. It's pretty off. So yeah, major problem with what the Commonwealth is asking for here as far as a remedy. You're not going to get, and you shouldn't get, a flat gag order. That's not justified. It's not tailored, and that's going to infringe on protected constitutional activity.
Thank you, Your Honor. And may it please the Court. Your Honor, as I mentioned at sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today. And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order, it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply with the court's protective order. That's evidence that I did not intend to violate the protective order and that I was mindful of it in that instance. Regarding the communications involving Mr. Proctor, I frankly and simply did not connect that topic to the protective order when I was drafting it. It just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him, and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate, and I recognize the court's discretion.
So they're conceding the violation.
In this, with regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial. His opinions about my client and me were publicly aired at trial.
Yes.
When his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication,
Marginal.
I will note that it was certainly not an instance where I, flagrantly revealed or even inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety, I would submit. At all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's.
And he's already
crimes.
subject to discipline.
So further information
Mention that.
coming to light in this motion, that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief. Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order that this communication brought by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here, and as well as whether there is a degree of prejudice that would warrant a sanction. Thank you.
Do you want to address the disclosure of grand jury minutes?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
I did, and I do have concerns about my ongoing obligations, so perhaps I could have a moment, Sandra.
Sure.
Well, I appreciate that what Mr. Yannetti has just done is made a public demonstration that the Commonwealth could certainly benefit from, that this is what accountability looks like. This is what accountability looks like. Yeah, I did. It got past me. I double checked. Then I realized, oops, I called him. And now here we are. And so there's no making excuses. There's no look at everything the Commonwealth has done, which would be so extremely justified in this case. So justified to use Mr. Brennan's little method of trying to smear the defense as if that's some kind of justification for his own affirmative position, right? Dr. Crosby should be allowed to testify because Dr. Russell, like, no. It's not an argument, but he's going to continue to do that. The defense could have gone tit for tat with that. They had a whole hearing on Mr. Morrissey and his public statements, and the court even acknowledged, yeah, these cross the line. These violate the RPCs. But we're not going to disqualify him. We're not going to disqualify the office. So he didn't do any of that. He just said, yeah, you're right. This happened. So the issue is, what's the appropriate sanction? What should you do about it? And here's why, here's what we think you should consider. He doesn't even address. I would have been all over. Obviously, I was all on it right here. Their proposed sanction is constitutionally problematic in so many respects. The First Amendment rights of the public to the record of the court proceedings, the First Amendment rights of the attorneys to be able to speak on behalf of their client, the Sixth Amendment right of Karen Reed to be able to present a defense, to be able to freely litigate the issues that need to be litigated and to make her record of those issues in court. All of these are implicated by what the defense doesn't get to file stuff publicly, and they don't get to make any public statements. But he didn't even jump on that. And I like what he did. I think it was very gracious to just go back and point out, this is why we have the protective order. So this is what's implicated. And that's why this is de minimis. That's what he's saying. He's saying this is a de minimis violation. It wasn't intentional, but nevertheless it was. And so in light of that, that's how you should craft whatever sanction you're going to craft. It's fair. I think that's fair. Is this really tipping the scale, this information being in the public domain? Is that going to really tip the scale with a prospective juror that hasn't already heard about this case, but they hear that Proctor had bad things to say about AJ? And now, therefore, they're going to be prejudiced against the Commonwealth? I mean, no, come on. Come on. That's ridiculous. So it's really a no harm, no foul situation is what he's getting at. What should it be here? Fine. Fine him. Hit him in the pocketbook, gets his attention, imposes a consequence, shows him you need to read the protective order again, make sure that you know what's covered. That would be justifiable. But a gag order, and you have to file all the defense stuff under filing. The Commonwealth just did the same thing. They just did the same thing when they outed in their response to the motion to dismiss that Lieutenant Fanning of the Idaho State Police is the one that the motion about jury tampering is about. We didn't know that. We didn't know that from reading the defense motion. Why? Because all of the details in theirs were redacted. Either because it has to do with the sidebars that were impounded, or because it has to do with the federal investigation. I don't know which reason. I'm not really sure why they mentioned the federal investigation at all in their motion to seal and to redact. Unless it's just kind of this multiple layers of, well, the sidebar talked about the federal investigation and you know, I don't know, but what would the handling of the jury have to do with any of that? Unless the federal investigation was still ongoing at the time of the trial. So it's just, this whole situation is so messy, and the more they try to ratchet it down and keep it out of the public eye, the more questions it raises. I mean, that's always been the issue with trying to keep the process under wraps, is it means that people then are just going to speculate. People are going to try to figure out what's happening because you're not telling them, you're not letting them know. And so we're doing our best to infer what we can from the circumstances. And in many ways, that's a lot worse than just coming out and telling us. But it's the Commonwealth that disclosed the substance, apparently, of the sidebar conversations and or details of the federal investigation by naming Lieutenant Fanning, who is all redacted in the defense's motion. So it's really one of these, it's an unclean hands problem. There's a very, very big unclean hands problem from my perspective, with the Commonwealth wanting sanctions under this type of circumstance, while the Commonwealth has still continued to not take any accountability for any of their own similar violations. They defended Michael Morrissey Probably still are, but certainly defended him to the very end in that whole process. Tried to justify the statements. Never said, you know what, yeah, maybe this one does cross a line. There's a thing that Mr. Brennan does that I just noticed that he's going to continue to do this at trial because it's just his style. And I kind of hope he does, because it's so unpersuasive and off-putting. And it's this resorting to this extreme absolutism. There's absolutely no basis for this claim to be made, or no possible reasonable inference. Well, the thing is that the jury is going to be sitting there with a mind of its own. And a juror who's sitting there thinking, that seems like a reasonable argument to me, is now basically being told by this prosecutor, you're an idiot. They're being gaslit by the prosecutor that you're not entitled to think this. And it doesn't come off well. It doesn't come off persuasive, because a juror who has some kind of confidence in their perspective, it's going to be like, no, actually, that is a reasonable inference to draw based on the content of what he said in that text message. May or not mean it did or didn't happen. I don't know. Maybe we'll have to ask him on the stand. Don't know. But it's a fair inference from what he said. You weren't supposed to be watching the closing anyway. You weren't supposed to be watching the closing anyway because you're under a sequestration order. That should be your reason why you're not watching the closing, not because Alan Jackson sucks or whatever. Because you can't stand to listen to him. It's because you were ordered by the court not to, and of course you're dutifully following that order that the Commonwealth is here arguing is sacred. So yeah, based on the content, it's a fair inference, a fair argument to make. Is it conclusive? No. But to be up there waving that there's it's absolutely no basis, no inference. It's too strong. It's not correct. And, a jury that has a thinking brain is going to be able to look at that and say, actually, that does seem kind of reasonable to me. And so now you've lost credibility with the jury. If you sit and lecture the jury that they can't do what they are plainly already allowed to do, perhaps inclined to do if they're thinking people, you're just creating distance, creating space between yourself and the thought process of that juror. And so if you can't be in the same place, if you can't lead and pace the jury, leading and pacing, you're getting them on the same page. But you got to do that in a way that's reasonable. You got to be able to connect with them. And telling a juror you're unreasonable, your thought process is impermissible, it's not effective. It's not going to be effective. So I'm going to be very interested to see. I mean, I think he will, because it's the hectoring style is his style. I don't think he's going to be able to shift gears and suddenly be reasonable and nuanced when he's in front of a jury instead of in front of a judge. Maybe he can. Maybe he can. I guess we'll see. Bluford. I was talking about Bluford versus Arkansas. That's the, or not Bluford. Sorry. That's the other one that has to do with the federal habeas petition. Gentile versus state of Nevada. Yeah, pretty clear standard pretty clear standard. They went and looked at the Nevada equivalent of RPC 3.6, which is, mostly the same in most states. One of the big differences is whether or not the rule gives a right of reply. Some states have a provision that says, well, an exception to this is that if you are fairly responding to something that the other side initiated, then you can go ahead and make the statement, which seems fair, because if they get to poison the well and you don't get to do anything to correct it, the well just stays poisoned. But some states don't allow that, don't have that exception. That's really the main difference between them. And the big reason why is because of this case. And so what happened in this case is this lawyer, he's representing a criminal defendant, and he gets on the stand. He makes a press conference, or not gets on the stand. He has a press conference, and he gives this prepared statement that's got all kinds of like details about case and his opinions about it and so on and so forth, the evidence and yada yada. Said that they were trying to convict him as a scapegoat, that it was the police, crooked police, who did it, not the defendant. Like, this is pretty squarely on point. The lawyer's making a statement saying my client's innocent and he's being framed by these crooked cops. And he says this in a press conference. And the U.S. Supreme Court says, yeah, it's First Amendment protected. You can't apply this 3.6 rule to that statement, because you have to consider what is the interest that 3.6 is protecting. It's the right to a fair trial, to an impartial jury, to a proceeding that is, reasonably fair to both sides. And it doesn't implicate that. You're looking at the time for trial. You're looking at the context. You're looking at what's the substance of what was actually said and what's it responded to. It's only related to the dissemination of information that one knows or reasonably should know has a substantial likelihood of materially prejudicing an adjudicative proceeding. Materially prejudicing. So things that are typically going to count under this standard are things like, first off, the timing is very important. It's one of the reasons why they mention, it's, a couple months before trial. Well, a couple months before trial is still honestly kind of quite a ways before trial. Now, it's closer than Gentile. Gentile was 6 months before. But that was a factor that favored in front of the attorney in Gentile. It's like, it's still a ways down the road, and the press cycle being what it is, things come and go. Sometimes there's a lot of attention paid to it. Sometimes there isn't. But there's plenty of time for memories to fade before you're actually, bringing the jury panel in and trying to seat them for the case. Substantial likelihood of materially prejudicing an adjudicative proceeding. This is things like information that is not going to be admissible. Like maybe it's already been excluded, and, on the eve of trial, you're out there with a bullhorn trying to communicate all this stuff that the jury isn't going to be able to hear any other way. That kind of thing. That would have pretty good likelihood of material prejudice, because you can't unring the bell. And you can't rely on the protections of the court process to now guarantee that the jury isn't going to have prior knowledge of this inadmissible information, and that isn't going to factor into their decision-making process. That's the type of thing that this is about. Not a minor, marginal, we already know Proctor sucks. We already know he's a big problem. We heard all about it in the first trial, and now we know he's on admin leave, unpaid admin leave, while they have him going through disciplinary proceedings. May or may not get shit canned from the department entirely before this trial is over. But it's going to come up. It's going to be impeachable. You're not currently active as a member of law enforcement, are you not? And the reason why relates to your conduct in this case, does it not? Yeah, it's going to come out. So, a text he sent where Alan Jackson sucks, and it implies that he was not considering the court's order on the sequestration of witnesses. That wasn't his driving consideration in not listening to the closing statement, but just his antipathy towards Mr. Jackson. Substantial likelihood of materially prejudicing an adjudicate. Yeah, no. No, there's no material prejudice. It's immaterial. It's so marginal. This is I don't even know how you would make the argument with a straight face that this would somehow be the straw that broke the camel's back. When the entire trial is already in the public domain. They already had their first bite at the apple. We know what the evidence is. That's why we have opinions about the case, because we're informed now. Not because we're coming in biased or we don't know or we've been tainted by partial information or whatever. No, because we watched the entire damn trial already. We already know what your case is. We already know what your basis is. We already know what your justification is. And we already know what the serious problems are with your theory of how all of this went down. And we know about the problems, the serious problems with the credibility of your witnesses. While we're talking about the credibility of the witnesses, oh man, what I really want to see from Mr. Alessi in this next trial, I really want him to be the one who cross-examines Jennifer McCabe. I really want that. I want that so much. Because number one, he has the mind for details that is really critical for a witness that's got a lot of potential impeachment testimony, a lot of inconsistencies between the various times that they have made all of these different statements and given reports. He's so skilled at being able to systematically lay them out. You know, he's going to be able to identify the first time you interviewed with police, you said this. Oh, that's in their report. So you say that's a mistake. Then the second time you said this, and that's different. And then, you know, he's going to be able to lay all of that out. She's going to have her excuses. Some of them are just going to be, you know, like we already heard. That's wrong. That's all going to go into closing and then into cross-examination of the other witnesses, right? She said, this is wrong, 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 this is wrong. And at the same time, the Commonwealth's own witnesses are saying they made all of these mistakes, and yet they want you to believe the one thing that they got right is that Karen hit John with the car. So the organization of all of that is very powerful. It's a very powerful tool that they have, and that's such a skill set that he has, is being able to identify those details, methodically present them, and then to explicate them, to show the jury the significance of what it means that all of these inconsistencies have taken place. He's not going to be as easy for her to shake off the hook, you know, with some excuse, some word salad, some misdirection. he's not going to be easy to shake because he's so methodical. He knows what question he asked, and he knows why he asked it, because he knows what point he's trying to get at, and he knows what is in his arsenal to be able to establish that point. You're always asking the witness a question that you already know the answer to, and you have a way to substantiate it. That's what cross-examination, the technique, is all about. And this guy, he cross-examines experts. He cross-examines professional witnesses. So he's got to have this absolutely down to a science. Because a witness who has testified hundreds and hundreds of times, they got a lot of tricks. They have seen all the different styles that the lawyers have, the ways that they try to pin the expert down, try to put words in the witness's mouth, and they learn how to adjust to that, how to adapt to that. So he's going to be very, very, very good at managing slippery witnesses who don't want to be pinned down. But that's literally what your job is. That's all it is on cross-examination. You already have the statement they made in a police report. You already have a statement they made in prior testimony. You already know what fact it is you're trying to elicit and how you're going to be able to elicit that. So it's going to be harder for her to get off the hook, I think, with somebody like Mr. Alessi. Not criticizing Mr. Jackson. You know, Mr. Jackson, very skilled lawyer. But it's just a different skill set. It's a different skill set that Mr. Alessi has. And I really, my sense, given what I've seen from him in these pretrial hearings so far, he has the skill set that is going to be most beneficial against slippery witnesses like Jennifer McCabe. So I really want to see that. Really want to see it. And there gets to be more and more and more, right? I mean, whole part of the basis of the motion to dismiss, more inconsistencies, more changes to the story, more who was there, who wasn't there, what was it about, what did you do, what did you say? We're going to get another, this report was wrong. Can just about guarantee it. Why? Because that was one thing that came through crystal clear from Jen McCabe's testimony. She was never wrong. Never wrong about anything. Everybody's wrong sometimes. And Mr. Yannetti just gave us a demonstration of what's really the best way to handle that. The most persuasive way to handle that is you acknowledge when you're wrong. And you can try to explain why, and you can try to mitigate, explain why it happened and what the consequences of that were. Recognize all of that. That's called having insight. And it's a persuasive thing. It goes hand in hand with authenticity. If this person has insight into their own deficits as a reporter and as a witness, it's going to be a much, much more persuasive witness than somebody who is never wrong, blames everybody else, doesn't acknowledge, the unavoidable. So there's a lot. There's just a lot of potential ammunition there, and he's really the one to manage that, to make sure that it doesn't fall through the cracks. That some of this stuff doesn't fall through the cracks. Well, while we're still waiting, I don't know if they're on. I mean, it's still saying a short break, but It is kind of the noon over there. I don't know if they're going to be taking their lunch break or what. I'm going to go ahead and take the chance to go ahead and go through some of our comments here. If they come back on, I'll get the courtroom back up. But, you know, I get sick of staring at that fan. I don't know about the rest of you guys, but fan gets a little old. So I want to welcome Red Pin to the membership. Welcome to the channel. James Casatelli, good to see you, James. How does the Commonwealth show that reversed video in a second trial? Will they? Can the defense? If they don't, I don't see how it doesn't kill their case. Yeah, I mean, oh, here we go. I'll just hide this for now, but I'll come back to it.
Thank you, Your Honor, and thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make in...
We did that because that was material that needed to be done at sidebar.
Oh, I understand, Judge. No, and I'm thanking...
I want the record to be clear.
I understand, and I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the First Assistant U.S. Attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that. It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and Mr. Brennan was aware of that because he personally got the letter. It was only after that that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement, and what was the date that you all found out about what Mr. Brennan just announced?
Okay, so January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information? When did you hear the information that Mr. Brennan just told us?
Mr. Brennan called me to inform me of that. I don't remember the date. Maybe, perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after February 18th. Yeah, no, it was definitely after February 18th. Ms. Little reported the freshest information that we had truthfully to the court. So just in closing, Judge, this was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th, and it's right there in black and white.
Any follow-ups?
Oh yeah, let's have more wild flailing and smearing.
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. The import of the argument is not that the defense was aware
So why'd you wait a week?
And continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
Okay, but stuff was happening in the federal court. There's a federal district court protective order.
I want the court to take particular care when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in
Thank you.
court to Your Honor. The Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
But not 3.6.
Okay. Thank you. So what I'd like to do now, there are new motions that were really just filed. And what I'd like to do, I have one that has a response. So it's the motion to amend the scheduling order to give the defendant a little bit more time for their motion to dismiss and the Commonwealth's opposition. I would like to hear that now. I need to give them a minute. The parties have any problem hearing that motion now? It is a
No, Your Honor, I think it's very brief.
motion. All right, so I need 1 minute, Mr. Jackson.
Of course.
Can you write it to me again? The ones from this morning, the new ones? That was from the morning. I have to check. All right, so you're both prepared to argue this motion, right? The motion and the opposition?
I'm so sorry. Your Honor.
So both sides are prepared to argue this, the motion to amend the court scheduling order?
Yes.
And the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition and just informed defense counsel if they're looking for a date this week if the court's available. I just don't want this to linger because.
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I speak with counsel?
So she's entertaining it. Guess she doesn't want to have court tomorrow.
May I address the court, Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G-I-A-M, P-I-E-T-R-O, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of sallyport videos, and then about another 15 actual videos. I basically...
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
24 new videos and 400 pages of new discovery after the certificate of compliance is filed.
At 9:30 p.m. to download everything. I cannot represent to the court that I've gone through it in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves drowning files that cut in and out. There's about don't quote me on the exact number, I believe approximately 9 videos from the Sallyport garage, maybe 12. I have not watched them in detail.
But have you noticed the quality? Is it something you can actually see, or is it blurred and?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
Thank you. All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm genuinely ready. I just want to make sure I'm not missing anything, leaving anything on the
So
table.
what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just wanted to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, I assume it was Ms. Little's motion filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue that
I have not looked at them, Attorney Lally did, and he represented that they're all the videos we've already turned over, same quality as we previously provided. They're just copies of the same videos, although I do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting them, we passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do, I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sallyport video and related evidence, that has to be filed by Thursday with the idea that we will have a hearing on this on Friday. We have Friday already blocked off. This way here, you can all leave for today, and we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Ms. Dianetti after 5:30 one night. So we need things filed by that court day. So you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Commonwealth's response, any idea?
Of argument time, Your Honor?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Oh, of course, yes, I believe we will, for sure.
How does that schedule work for people?
It works for the Commonwealth.
Right. I need to ask Mr. Little one quick question.
While he's asking for that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to just
Thank you.
go do that
Thank you.
and not have to come back here tomorrow.
Perfect.
Yes.
And I'm trying to consolidate this now so you can leave in half a day today, rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated.
Your Honor, 11 o'clock would work. I think I can make my flight. By the time we get done, I can get it to you. That's fine.
Great. I like that.
So where do we stand in the motion for reconsideration? It sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that. Obviously, we gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they received that. There is still metadata, we believe, on the Canton PD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert put in his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need, I know this motion is just filed, how long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
I think we'll file a written response.
Okay.
So
going to be a couple of days.
Okay.
And we have motions on maybe Friday.
Yes.
So I think I'll make a motion in writing that I think we will hope to have the weekend before it allows, because with all of these hearings, it's taken away quite a bit of our prep time.
All right. Can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday and I don't need to.
Argue and then file.
We can do that now.
Your Honor, I would ask for the same courtesy for the defense. We have all of our reciprocal discovery due on Thursday. We have all of our motions and we due on Friday. I know the court would like us to have, the brief as to the motion to dismiss on Thursday, and I would love to be able to get the court that. But I would appreciate a little bit additional time as well.
So I need to know how this affects the motion to dismiss though, right? You've had this since, so you've got these recent ones, but I need to know how that, are you going to argue that on the motion to dismiss?
Well, I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant, it might not change anything at all. I won't know until I have a chance to actually go through everything.
But I need time, right? I need to know by Thursday. Doesn't have to be a complete report, an outline even, would the Commonwealth be satisfied with an outline? You know what the points are?
An outline of what you are.
Who is using like a 1920s typewriter in there?
This disclosure of, this late disclosure of videos.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I'll want to supplemental very quickly thereafter. I have to decide this and put something in writing. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
May I have 1 minute,
All right.
Ms. Little?
Yet again, Commonwealth, take all the time you need. Go ahead and just argue without giving any notice to the defense about what your response is.
And the court's concerns. I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever. Could I ask the court if it's okay with Mr. Brennan, we can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings. Let's just argue this tomorrow. I will concede
This, what?
the motion to dismiss. I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to wait. I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow if that's okay with the court.
Are you waiving the additional argument that Ms. Little says? Are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation is true, and I don't think that we need to file a supplement, which is really where the hang-up is. I don't think we need to. If the videos are the videos, we don't need another supplement.
All right. Ms. Little doesn't look thrilled.
Right. The key was the waiver. I'm not waiving anything on Ms. Reed's behalf, but if we need additional time, we can certainly let the court know tomorrow that we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay, what's the Commonwealth's position?
I'll defer to the court. I know it's more complications with the defense and travel will be available whenever.
So I think we did log off today and tomorrow.
Yes, you did.
With the understanding that the defense team would not be here until sometime 11 o'clock or later. What about, Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here on Friday.
If you're going to be here on Friday,
I just won't be here on Friday. So if we do the motion to dismiss tomorrow, I can head back tomorrow evening, and Mr. Little will handle her motion anyway.
I I greatly want to accommodate the defense as we have the entire time we've been here, but we have trial prep to do as well. And the more court hearing days we have hours of conversation, the more time we can meet with witnesses and prepare our case. And so I want to make things as easy as possible for the defense. I do.
All right, so Ms. Little already filed the motion. We need to reconsider. Why don't we hear that tomorrow as well?
Very well.
Okay, and we'll just finish up everything tomorrow.
Very well.
All right. All right, and then you won't have to be here Friday, but the motions in limine are all filed. It also involves filling out a final trial conference report. So
Understood.
we need to do that as well. That all has to be done by Friday.
Understood.
And then, you know, my goal was not to bring you back one day at all next week, because then we're going to full hearing, I believe it's the 18th, on the motions in limine.
That's right, the 18th.
All right, so you have a whole week next week to, you and I both,
Okay.
try to get everything done.
Should we file a formal motion to ask the court's permission for delay from Friday till Monday?
For the
Motions in limine.
Commonwealths were due on, the defense were due on Thursday, Commonwealths on Friday? Or were they all on Friday?
Reciprocal discovery is due Thursday. We want that to happen. Motions in limine, I believe, are due Friday.
Ms. Little, would you like the weekend for all those motions in limine?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you
All
very
right,
much.
motions in limine to be filed on Monday.
There's one additional housekeeping, Your Honor. There is a matter. There is also a motion pending, the dollar motion for Dr. Wolf. It has not been heard yet.
A Daubert motion for,
Dr. Wolf, it's a neurologist. So there's
oh,
one
I thought you
additional.
meant, I was thinking the archivist.
No, Your Honor. It's the neurologist of the Commonwealth. Wolf without an E, WOLF. That was filed 2 weeks ago, I believe.
I have not seen that.
Okay. I'll make sure that the court gets a copy, but I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a Wolf as well, and I received their Lank motion, and we'll be prepared anytime to argue that.
Do you want to argue it tomorrow?
I'm comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow. All right.
So another
If
motion.
you get word that you'll be leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just contact the clerk's office.
Sure. Okay.
Anything else for today then?
Nothing to finish on.
So I'm going to give you all why don't you put up all the things I'll be up to.
Order the court, Wall, Riley, please.
Not sure what happened there. Seemed like they were sort of chit-chatting about if there's anything else, and she's eager to get off the bench. So still don't know if we're going to be coming back to court at any point today. Goodness. What does that mean we got tomorrow? We got the motion to dismiss. We've got the argument on the motion on the metadata. And now we've got a Daubert motion on a Dr. Wolf, a neurologist for the Commonwealth. I don't think I've seen this one. If anybody out there has seen this one, let me know. I'm not familiar with it. I wasn't aware that the Commonwealth is bringing in a neurologist at this point. Obviously, I'm sure this has to do, well, I shouldn't say obviously, and I shouldn't expect, right? Because they could be making some argument about Karen and, you know, intoxication and MS or something like that. But the logical thing seems to be that it would have to do with John O'Keefe's injury, with the brain injury and the fracture, and potentially like what that would mean in terms of the impact to him and his functionality. You know, is he going to be unconscious? What's the effect of that going to be? That's what I would anticipate. But I don't know. I don't know. And it seems really, really hard at this point To assume that any of these Commonwealth experts are going to stay in their lane and or testify about things that are reasonably within the scope of their expertise, so I don't know, maybe he's just gonna come to tell us about the apron being shoveled at the fire station. Who knows? So tomorrow at 11 Eastern, that's great. I love it. That means 8 Pacific, not 5 Pacific or 6 Pacific like it is today. That's okay. I'm still kind of on an early schedule. My time, everything is messed up for me right now. I'm still very, very disoriented. It was summer, of course, in the Southern Hemisphere. I wasn't in a place, except for the last couple of days in Santiago, but most of the time I wasn't anywhere where like it's really hot. But the days are so long. And so, still adjusting to being back, and the days are short again. The other thing that's so weird about being down in the Southern Hemisphere, especially down like really far south where I got, like in
closure at the end of the last hearing, where it just kind of was left up in the...
They're done. So, way down south in Isla Navarino and down like on the Strait of Magellan at Punta Arenas and places like that, the sun is very low in the sky. And I'm used to that because I'm pretty high in the northern hemisphere, right? So the sun never gets completely overhead, even in the middle of the summer. It's always a little bit down in the southern sky. It's the same thing, of course, in the southern hemisphere, except that the sun is in the northern sky. And I can't even tell you how much that threw off just my equilibrium and my sense of direction. I've normally got a pretty good like internal navigator, can locate myself. I remember where I've gone. I can find my way back, that type of thing. But just something about that sun being in the northern sky, I couldn't adjust to that. I would have to like think about it and it would mess me all up. So anyway, I'm still kind of all over the place with like where I am and what time it is and stuff like that. So starting at 6 a.m. today was really not a big deal, but always like a little 8 a.m. start a little bit better. So that means tomorrow they will have the federal hearing. We might get some information about it. Maybe someone will live tweet or we'll get, quick reports about it before we go into this hearing. I'll be keeping an eye out for that. But it'll be a little bit of a wait and see. So I will plan on being here tomorrow to follow up on that. The motion to dismiss, that's beefy. That's what I want to hear, how she's going to handle it. If she's only going to set aside 1 day for it, then sounds like we're not taking any testimony. We're just having argument. Not necessarily going to call any witnesses unless it comes up. So, I don't know. Seems like in some way the defense is maybe kind of conceding that it won't be necessary, that they don't expect it. I don't know. Well, that was a fair amount to get through today. Alessi on fire again. The issue with the sanctions and Mr. Yannetti and the disclosure of the Trooper Proctor text really seems like a no big deal to me, but it's an opportunity to slap the defense. So I kind of expect that to be taken. I honestly, the same thing with the motion as far as, there was never any motion filed. The sort of spontaneous bringing up of the issue with candor to the court regarding ARCA. I'm kind of expecting a similar approach to that as Judge Gull took over in Delphi when they got the defense attorneys kicked off the case. She booted them off the case. They took that up to the Indiana Supreme Court. The Indiana Supreme Court reversed her. And the prosecutor then files contempt sanction against them, tries to go after them in a whole separate process to get a factual finding that would justify a sanction. And ultimately, at the end of the day, same issue that we're talking about here has to be a knowing violation. And the issue in Delphi was that somebody else who had access to the defense's office because they were an employee or a former employee had gone into the conference room, Mr. Baldwin's office, and had taken photographs of some of the discovery materials and then disseminated that. The discovery materials are under a protective order. So same issue as we have here. It wasn't knowing by any part of the defense. There's absolutely no way you're gonna be able to meet that standard. But she took the opportunity to write this, opinion where she abuses them verbally and berates them and calls them sloppy and negligent and all of these terrible things, while at the same time, concluding I don't have a basis for finding contempt here or imposing a sanction. So I'm kind of expecting something like that with Judge Cannoni. She's got to acknowledge the realities of the law, the limitations, the implications of removing an attorney, one of Karen's chosen attorneys that she has a right under the Sixth Amendment to choose. It's just too significant for her to be able to mess around with. And the choice of counsel issue, it's a great one on appeal. It's a great one on appeal because it's not that it's structural error, but it kind of is, because there's no remedy for it. There's no recourse for it. If she's forced to go through trial without somebody that she's chosen to defend her, that in and of itself, it's irremediable. So it's a very strong issue on appeal, and she's going to have to keep herself, cognizant of what the limitations are when it comes to her ability to interfere with that. So I think she's going to have to acknowledge the realities of the law and the limitation it imposes on her. Mr. Alessi has been quite adamant about that, and he's provided a lot of authority for his position. So I don't think it allows her to remove Mr. Jackson or, frankly, any of the members of the defense team, no matter how much she might like to. But she'll take the opportunity to write an opinion chastising them. Sloppy, dishonest, you make yourself unreliable, just some kind of junk like that. While either not sanctioning them or opposing, some kind of de minimis sanction based on like the February 16th memorandum or something like that. That's what I anticipate, but we'll see. So, another big day tomorrow. Let's go ahead and get back to this question, which is, a very intriguing one. How did they show it in the second trial? Have they kind of committed themselves to presenting that, since according to them, that is the original format as it was captured? From my perspective, they have options. They don't have to. They could go ahead and, show the one that the defense did, or even themselves go in and modify that video to show the correct orientation. And then you just explain to the jury that that's what you've done. You have modified the video. It's not the actual video that came off of the recorder, but you did that so that it would show the sallyport the way the sallyport looks from the correct perspective. Could have done that the first time, but didn't. It's going to come out no matter what anyway, because it's going to be impeachment as far as it goes to Trooper Buchanan in that prior testimony that he had given about how, look, you can see that Proctor isn't anywhere near the right rear taillight. And, if we see it in the correct orientation, we see Proctor is actually right near the right rear taillight. And yes, the Commonwealth is going to try to minimize that. But it's going to be for the jury to sort out, does that affect his credibility or not? So it's all going to come out anyway, in the prior trial, in your previous testimony where you said you can see that he's clearly not anywhere near the right rear taillight. And isn't it true? That's because you were looking at an inverted copy of the video and you didn't tell the jury it was an inverted copy of the video. I think the door is going to be open for all of that just through the impeachment process. So how doesn't it kill their case? I don't know. It didn't kill their case the first time. Didn't kill their case the first time when they did it in trial. When they did the whole misleading the jury thing, it didn't kill the case. So it's just going to be one more thing that goes to their credibility or the lack of it. Melissa Dotson is a YouTube member. Welcome, Melissa. Thank you so much for supporting the channel. Melissa Dotson, got to replenish Andrea's Patagonia funds. Welcome back. We missed you. Well, thank you so much. That is very generous of you. I can't wait to get back to Patagonia. I need to just move down there. Okay. If anybody has a line on like a nice ranch in Valle Cochimo, that's my, my new heaven on earth. I've discovered Valle Cochimo. It's known as the Yosemite of South America. And so when I first heard this description, I'm like, bitch, please. Okay. I've been to Yosemite like a lot of times. Yosemite is spectacular. It's absolutely one of the great wonders of the world. I was just there, although I didn't go into the valley very much. But I was just there last fall when I did my big road trip down the coast and then came back up through the mountains. Come on. Yosemite is South America. Oh, guys, they're not kidding. They're not kidding. And not only is that a fair description, because it's the same thing. It's these big granite extrusions that have been carved by glaciers over many, many millennia. It's just created all these beautiful rock formations, this huge climbing area, all this cracked granite, all these different routes that the climbers can take up. So it is very similar to Yosemite in so many ways. But the best thing about it, there's no road into it. There's no road in. So it's not full of like a couple 100,000 people every day and a bunch of buses and huge RVs and stuff like that. And just the crowds and all that. It's not there, because to get to Valle Cochimo, you got to walk down the horse trail. You got to hike down the trail that for hundreds of years, people in Argentina and Chile have used this trail basically to move cattle and move goods but back and forth between the countries. There's all kinds of legends in this area about back when Butch Cassidy had fled down to South America before they were captured, and they ran cattle back and forth between Argentina and Chile. There's all kinds of legends about this trail they used, that trail they used, but Cochimo is one of those. I'm hearing court's back, but is it? Let me see here. Court TV's not showing it. Is it on Law and Crime? Well, they have the fan back up. And to see if anything has happened here. I'm not seeing much. Okay, here it looks like there's maybe something. I'll go ahead and pull this up. Okay, let's see what we've got. Something was happening. Oops. Okay.
Session, you may be seated.
Okay, so where do we stand? If there was something you all were talking about, is there anything that concerns you?
Not at all, Your Honor. I think the schedule that the court had just articulated is the schedule that we will follow. Mr. Brennan and I have discussed it briefly. The motion to dismiss, Ms. Gould's motion, which I can't remember the name of it. The motion for reconsideration, thank you. And the Daubert-Wolf motion, I think we can try to compact all those in together.
So we will.
Done.
All right,
Yes.
so Mr. Leslie, are you arguing the Daubert motion?
I'm arguing the Daubert motion, and I will compact it as Your Honor has just directed.
So let's finish all this tomorrow.
Understood. Thank you, Your Honor.
All right.
All right, so see you all tomorrow.
All right, to the court, please.
All right, so that's it. Just confirmation about what our schedule is going to be. So I guess that's good to know. We'll be back at 11 o'clock tomorrow Eastern. See where we're at. Anyway, all I was doing on that one was just ranting about Patagonia and how awesome it is. But anyway, yes, Valle Cochimo, it's amazing. So if anybody has a line on like a nice ranch or something near Valle Cochimo, hook me up. Hook me up. I can move my studio down there. I can still do all this from down there. And the nice thing about Chile time, it was great for streaming. I noticed that when I went back and watched some of the Koberger hearings, because it's 2 hours ahead of the East Coast, it's 3 hours behind the UK. It just works out really well in terms of being able to find a decent time that most people are able to watch. So yeah, a lot of upsides to Chile, guys. Thank you so much, Melissa, for topping up the Go Back to Patagonia fund. Sarah Boone's left kidney. Can the defense's new reconstructionist about Trooper Paul? Well, I would expect so. I would expect they're going to be able to deal with what was the Commonwealth's testimony that they presented in the first trial, and to what extent is that inconsistent with any type of theory that they're potentially trying to present in the new trial. So I would assume, assuming is so dangerous in this particular case, but just given what the rules are for discovery and disclosure and so forth, if the Commonwealth is using a new reconstructionist, they have to disclose that in discovery. And just like everything else, they've got to disclose the report, they got to present the basis of the opinions and so forth. So the defense is going to be on notice of what is he going to say that's going to be different from whatever Trooper Paul had to say. And so that shift in theory, I think, yes, that is conceivable, in part because, one, you would expect the experts to have relied on that and to have taken that into consideration when they were forming their new opinions. Certainly a defense expert would have prepared for a new trial based on, what was the evidence presented in the last trial. So yeah, I would expect it's going to open the door, and particularly if there is a change of theory, if Trooper Paul is no longer going to be presenting the mechanical argument for how all of this adds up to a car crash, a car collision. I think they're able to point that out because they're able, it just goes to reasonable doubt. The Commonwealth can't even give you a consistent story. They can't even come up with a consistent theory about how this accident happened. And yet they want to say that Karen Reed, did it. And, but they can't even tell you how it happened. It keeps evolving. Their theory has to change as we point out problems with it. And it just tends to show the tunnel vision. They're fixated on Karen Reed, and so they're just looking for justifications to try to argue that what they've already decided happened, in fact did, and instead of considering alternative theories about how this could have happened. They're just doubling down on trying to justify the conclusion that they've already reached. So yeah, I think that's fair game. Desert Cat, so glad we're all here. Me too. My prediction is the Lady Macbeth will shut down the defense. There's too many dangers for the Commonwealth. If she doesn't, she'll breathe heavily and pretend the defense did something bad. Well, we get to see tomorrow, right? Now we get to see tomorrow. Really doesn't sound like they're going to get into an evidentiary hearing. Doesn't sound like anybody's going to be called. There's a lot to do tomorrow. And, I think you're right that, yeah, let's say, because it's really on the Commonwealth to call the witnesses, right? They're the ones that need to rebut the factual allegations that the defense has made. So if we're not going to be in the context of assuming everything that the defense says is true, it's fine. and we're going to actually try to establish that what the defense said is not true, we need testimony for that. And that's kind of on the Commonwealth to establish that. So I can see a situation where we're having the argument and the Commonwealth is responding, and now the Commonwealth needs to call witnesses. And, is this going to take all day? Mr. Jackson, you should have anticipated that, we've got all these motions to get through. We're just going to have to come back on Friday. And yeah, it will turn into being the defense's fault because the defense has gone along with the court's recommendation to, compress as many things as possible into this hearing tomorrow. And the fact that, the Commonwealth would need to maybe mess that up, that would be a defense problem. Yeah, I could see something like that happening. But we'll see. I don't expect the Commonwealth to want to try to call witnesses. They don't. It doesn't benefit them to get into the details of the who, when, why, where, how of this handling of the video. It's not in their interest. That's only in the defense's interest. So yeah, I think I definitely did notice that when Mr. Alessi speaks, at least today, most of the time she doesn't butt in. She doesn't get in his way. She doesn't interrupt. She did a little bit when he was making the argument on the ARCA stuff and the candor to the court. She did jump in and interrupt him a few times on that one, but that was rare. And I feel like the main reason that happened is because that was a situation where the defense is on the defensive. They're in a defensive posture. They're being accused of wrongdoing. They're being accused of something serious, misrepresentation. There's potentially severe consequences on the table. And so it's a weak spot. And I think, to some extent, maybe there's a little bit of a sense that she can knock him off balance, knock him off of his game because he's already injured, right? He's already kind of hurt, already kind of spun. But when he's on his game, like he was today, no, she doesn't try to get involved with that because he's got an answer, right? He had that answer at the very beginning today. You're going to try to challenge Mr. Alessi on why didn't he bring this up earlier in his presentation? What a perfect answer was that? Duh, dumbass judge, because my presentation, as I said repeatedly I was going to do, but you didn't like me telling you what I was going to do, so I stopped telling you what I was going to do. Nevertheless, I told you, and then I did give my presentation in chronological order. That's why. Remember? No. If you come at Mr. Alessi, you're going to pay. He's going to make you miss, and then he's going to make you pay. That's really clear. So he'll be handling the Dahlberg argument. Should be good. I do hope I get to see that motion before we have the hearing tomorrow. So like I said, if anybody has seen that, I'm gonna go on the hunt for it. Tag me or something. But the motion to dismiss is gonna be Ellen Jackson. So I think we already kind of know. We already kind of know what to expect from that. She's gonna spar with him. She doesn't like him. She's gonna be resistant to what he has to say. She's gonna challenge his assertions. So in that sense, potentially just shutting down the defense. Yeah, I can see that being possible. John Beatty Bott. FYI, public defender who got woman named Penny acquitted of murder by heart attack by Bev at bench trial was amazing. Worth watching for many reasons, in my humble opinion. I will maybe go back and check that out. I did see, it looked like Melanie Little had covered that trial. So I just heard kind of little bits and pieces about it because I remember that was going on while I was kind of off the grid for, I think, most of it. I came back and like it was already at the verdict or something like that. But I did hear about that trial. I didn't realize that was in front of Judge Bev. So that's interesting. That's potentially worth checking out for sure. Thank you for that recommendation. That Southern Blonde lawyered. AB, so glad you're home, but glad you had a well-deserved break. This is Crypto Tax Lawyer. Hey, you had to change YouTube channel name due to a new job. Well, welcome back under your new name. Bev already got my blood pressure up, not even 5 minutes in. Yeah, she did. She wanted to start off trying to knock them off their stride, didn't she? She wanted to try to have them on the defensive right off the bat, and it did not work. It did not work. Alessi just got right back at her, and she had no answer for that. That's why she's trying to, like, what are you trying to imply or trying to get them to concede that, well, because it's nefarious, because we're trying to conceal the fact that they got paid? No, we disclosed it to the freaking Commonwealth. And so in describing how all of this came about, we went in chronological order, which is typically going to be the easiest way to follow a sequence of events. Yeah. She does get the blood pressure up, doesn't she? Nicola Maxwell has joined again. Welcome back, Nicola. So glad to see you back with the membership and with your wrench. Sarah Boone's left kidney is a YouTube member. Welcome to the channel. Alessi's big brain to free Karen Reed. Absolutely. Geez, I've missed you, Andrea. Glad you're back, Mrs. Mad World. Well, thank you. It is good to be back. You know, I'm not going to lie. Delphi was hard. Delphi took a lot out of me, and not just because it was, you know, a bit of an endurance test from a physical standpoint, having the 6 days a week, not a lot of sleep, not getting able to eat in the courthouse except for your little snacks and stuff like that. I was like on the cheese diet eventually, because I knew we reached the point where we knew we'd have so little time to eat that it was like, just eat as much find calorie dense stuff, you know, because you don't have time to eat things that are like healthy and nutritious and stuff. So I was kind of like on a cheese diet for a while. Not great. Don't recommend it. But it wasn't just that it was physically challenging. It was very, very hard. It was very hard emotionally, very hard. You know, just dealing with what seems like such an injustice, and not just because I don't agree with the outcome, but because of the process that led to it was so frustrating, so aggravating, so unfair. And you know, you see it a lot as a defense attorney. I've had plenty of years to get jaded about it, but it still doesn't fail to make my blood boil, because it's supposed to be better than that. So, you know, it was hard, and it was exhausting, and I definitely, you know, needed a little time to kind of recover from that. And boy, I feel so great now. Nothing like some time in heaven and in some adventure. And I love the reason I love the trekking stuff. There's just something I find very peaceful and satisfying about, you just get up and you walk, and you've got your bed and your food and stuff on your back, and that's just all you focus on is your steps and following the trail and paying attention to what's around you. And there's wildlife and there's smells and there's, you know, beautiful scenery and stuff until you get to your place where you're going to stop. And then you put up your house that's on your back. And it's very simple. Very simple focuses, basic things to focus on. That low level Maslow stuff, your shelter, your food, your security, like that's about all you're concerned about. So it is very peaceful to just kind of shut down that, you know, worry brain, anxiety brain, the brain that's angry about, you know, stuff that you've witnessed and stuff like that. Very, very, very regenerative. So I'm very glad to be back. It was a wonderful time away, but I am definitely ready now to be back in the arena. Andrew Hansen, this is going rough for the Commonwealth. Yeah, it did. Boy, Mr. Alessi, he is formidable. He is not going to give them an easy fight, like ever. And it's such an obvious, they're so obviously outmatched. That's what's so damaging to the Commonwealth about it. When they can't even address the actual points that he's making, because the points that he's making are completely undermining their entire basis for trying to say this guy should be able to testify. Yeah, it's really obvious. It's apparent from watching that they don't have an answer. And then he gets up and calls them out on the fact that they didn't have an answer. Yeah, okay, he's testified before. About what? About what? That's kind of the $1 million question, isn't it? So, John Beattybot, if she allows Crosby, it would have to open the door for ARCA on biomedical injury testimony about OJO. Yes. Well, it certainly seems like that, doesn't it? It certainly seems like that. If she's going to relax her standard that only a medical doctor can testify to the causation of injuries, and she's going to broaden it to allow other areas of expertise, then I don't know how we don't get into then biomechanical engineering is okay, because it is going specifically to the issue of how do objects work and how does the body work and how do the forces interact. I don't know how we get to a guy who studies dogs and has seen lots of dog bites, can opine about dog bites, can opine about, that this is not a dog bite. But we don't get a guy who has specifically studied injury production mechanisms, doesn't get to testify about that. But I'm also not going to put it past Judge Bev to find a way around that. Find a way that she can craft a standard that is broader than what she previously allowed, but is still going to exclude Dr. Rentschler. We'll see. Hanky Can't Do That by Bob Alessi. I'm from the Grand Ron Valley. Thank you for streaming, Andrea. Loved your walks in beautiful Chile. Oh, well, the Grand Ron Valley is itself a very beautiful place on earth. I'm glad you enjoyed it. I would have liked to have done a little bit more. Of course, most of the time I was off the grid. Also, because, I'm out in remote areas, I was kind of preserving my phone battery to take photos. Just wanted to make sure I wasn't going to run out when I don't have, the ability to charge for, 3, 4, 5 days. It didn't happen. I got close, but it didn't happen. But yeah, it just was going to limit my ability to be able to do videos. However, if and when I go back, because I do have ideas, I do have thoughts. I still got so much to see down there. That's the thing. I've been to Chile twice now. I've still never seen anything north of Santiago. There's a whole other half of the country. I've never been to Torres del Paine. It's like the most kind of notorious part of Patagonia. It's one of the main reasons why outdoor people go down to that area. I'm a little bit contrary. I'm like, well, everybody goes there, so I want to go to the other places. I don't want to go to the place where everybody goes. Well, I since heard while I was down there, from people I trust, like mainly Chilean people, no, you absolutely have to go. There's nowhere like it. It's irreplaceable. So, all right, I got that. It's on my radar. So I got to go back. But now that I know that, I got some ideas for how I might be able to, bring some backup video equipment, that isn't anything too crazy, too unwieldy, not a lot of weight and volume to my bags. So I enjoyed doing that, and I'm glad that you guys enjoyed that as well. Melissa Dotson gifted 5 memberships. Thank you so much, Melissa. Very generous of you. Michael Muddragon is a YouTube member. Welcome back, Michael. Good to see you. And CT Girl 5150 gifted 5 Andrea Burkhart memberships. Thank you so much. Thank you on behalf of everybody who got one of those. JT000, I pop in during quick break in my hearing day to hear that was a slaughter. Oh my God, I'm going to have to get straight back in here after I finish up. Alessi's not messing around, man. He is not messing around. He is not to be trifled with. Absolutely not to be trifled with. What an absolute coup for this defense team. What a score to have an attorney of that caliber step in and just kick ass. Look at him. Look at how good look at how detail oriented he is. Look at how thorough he is. You know, one of the things that I have, it's kind of like the dirty secret about lawyers, that, you know, you're not supposed to talk about because you're supposed to sort of maintain certain illusions about the profession and how it works and so forth. But I've gone ahead and mentioned it as like just the bar is often really, really low for being an attorney. Very common to see people making all kinds of representations and arguments and stuff about what the law is, and they've never once looked it up. They've never looked up the law. Like, the law is a thing that's out there. It's written down somewhere. There are sources for it. The actual practice of law is really little more than knowing what those sources are and going and looking at them and then incorporating them into your analysis of a situation, citing them, etc. And it's amazing how many people will have opinions, lawyers will have opinions about the law without ever even looking at the law. But not only is that bar like more than cleared with Mr. Alessi's, extremely comprehensive in his legal research, but look at what he does with the factual stuff. Look at the roads. He read the guy's theses. He read his master's thesis and his PhD thesis, 300 some pages of his academic work. Okay, that's preparation. Most lawyers are not going to do that. They're going to look at his CV. They're going to see it's there. They're going to see the subject matter. They're not going to go through and read the entire thesis. So the fact that he did that and then came armed with ammunition that he got from that, like this guy, I'm just telling you, he's next level. He is so far above the bar where just decent lawyering is set. He's extraordinary, and that makes him extremely dangerous. He's so dangerous. I just hope they can make very generous use of him in the retrial. Peter Sitchell, farmer, lawyer, boxer, anything you can't do. There is a lot I can't do. There's a lot I can't do. Stay home and not travel and have a quiet life. I'm not very good at that. No, I just, it's, you know, I'm not a farmer. I'm definitely not a farmer. Farming is one of these things. I remember, who was it? Who was it that made the comment? It was some politician that got them slaughtered, or maybe it was some intellectual about how like, oh, farming is easy, but easy. You know, you just put some seeds in the ground and water them or whatever. No, I'm here to tell you farming is really super technical. It's very difficult. It goes into timing. It goes into, breed, what specific thing are you trying to grow, and what variety, soil type, alkalinity, how much water you have, do you irrigate, how much do you irrigate, when do you irrigate, why do you irrigate, weed management, pest management. Like, there is so much that goes into growing food that people who have never done it just don't have a very realistic image of. And I do very basic things. You know, I have like my regular, kind of routine vegetable garden. What I do that is maybe a little bit, more than what any sort of backyard gardener does is the fruit trees. And that's something that I grew up with. My family's always done that. Never commercially. We don't have like commercial orchards in my family, but we've always had fruit trees. My father or my grandfather came from a farming background, so he was, very familiar with all that stuff. Learned a lot from him and just kind of always did it growing up. So it's, from my perspective, I don't do anything extraordinary. very different what I do than if I were trying to like run a commercial orchard. It's a whole different level. Whole different level, and all kinds of different things you have to consider. So I appreciate the compliment, but I assure you there's a lot that I can't do. And what I do, I mean, I think it's pretty cool, right? But it's just, you know, it's just things I do. It's just things I do. Jason Sorensen, as a farmer, we are well aware of soil science. Yes, you are. There are whole companies based on this discipline. Also, ground hardness isn't based on cold. Well, I mean, yeah, cold is going to be one factor that goes into this calculation. And the only reason why the cold is going to affect it is because that's going to affect the water. It's going to affect what happens with the water in the soil. But it's very important that it's cold over time. It's not just cold at some particular point. It's not like these processes all occur instantaneously. And that's why it's a very complex model to figure out what is the effect of temperature on any particular piece of soil, because it matters. A lot of these details matter. So yeah, there are entire companies that will come out, they will test your soil to tell you what kind of qualities it has, and therefore based on that, what sorts of crops are going to be, most, they're going to do the best in that type of soil, what type of amendments you might need, how it's going to drain. So what types of precautions you need. Again, when we're talking about irrigation, how much irrigation, when do you irrigate, your patterns of how you plow, how you till your ground. That can matter based on, water, slope, exposure, soil, like all this stuff. Farming is really super technical. So yes, I 100% agree with you. For them to be walking in like this is just a weatherman question, it's ignorant. It's ignorant is what it is. Lena B. Andrea, your knowledge never ceases to amaze me. Thank you for educating us and make us laugh too. Sending this with huge admiration. Well, thank you so much. I really appreciate that. It's nice to hear. I just have a lot of interests, and I do like to share my interests, and I read about a lot of things, and I try a lot of things. I'm really not a specialist in very much except for, my Washington criminal law practice stuff. But that is the nice thing about being a lawyer, is it just gives you a broad base for being able to not just understand the system broadly in the 10,000 foot kind of perspective, but also where to find out the answers. Where do you go? That's what legal work is going and finding answers and knowing what the resources are and where to look and how to make sense out of it. So that is one thing that I think helps in terms of building a broad knowledge base. Unduly noted. Andrea, can the judge prohibit reference to the first trial and the federal investigation again? Re Trooper Paul, if the Commonwealth doesn't call him, can the defendant, and how? Well, yes. We mentioned this a little bit before. I believe, yes, they can absolutely raise this to the extent that it's an impeachment of the Commonwealth's investigation and the impeachment of the Commonwealth's theory of the case, and how that theory has had to evolve over time because they are fixated on trying to find a justification to convict Karen Read. And it just goes to the argument that they're not interested in the truth. They're not following the facts wherever the facts lead them. They have a destination in mind, and they are having to, change their theories and call new witnesses and so forth to try to justify reaching that final conclusion. So in that sense, I think, yes, that is at the very least going to be on the table. Now, can they get into the very specific, there was a first trial, there was a federal investigation? I don't know, potentially not. I could see her having that, restricted like she had in the first trial, where we have to talk about a different proceeding or something like that. Maybe that's what it'll be here, They get to say a different proceeding. But I think a lot of that is just going to depend on the context as well, and the extent to which the door gets opened. I mean, I think there is a big risk that the Commonwealth opens the door, and the ARCA witnesses are where I see the biggest potential for that. Because if the Commonwealth is going to try to impeach the ARCA witnesses, to try to argue that they're biased because they received payment from the defense, then I don't see how the defense doesn't get to put that payment in context and explain exactly what it was that they paid for versus what they did not pay for. And that's necessarily going to bring up the fact that they were required to testify. They were required to come on 2 separate occasions and testify because the defense subpoenaed them. And it wasn't for the work that they did, the opinions that they developed, and so forth. So I think the answer to this question is generally yes. I think she probably can. She can say, oh, it's too prejudicial, as far as like specifically referencing the previous trial. But is that actually going to be how it plays out? It's going to depend on just a lot of things, and I think choices that the Commonwealth makes as well. Full melt hash values. These usernames, you guys are getting like more and more creative. I feel secondhand CTE from the beating Alessi is giving Hank. It was a curb stomping, wasn't it? Oh man, I'm happy to see more of that. I really am. Yeah, it was. Because if your whole argument is that, well, this guy can testify about some things, you're not addressing the core issue here, which is, can he testify to this specific thing? And I've noticed that's kind of a common diversion, deflection. When you have a serious criticism of something, that's kind of one of the common ways to do it, is to just talk in generalities and not focus on the specific details that matter. So I got in a little Twitter fight yesterday. You know, it happens. Nothing serious, but it was based on when I was on Melanie Little's show. Somebody had pointed out to me, somebody messaged me on my Substack and pointed out to me, they just had a question. They're like, hey, I noticed that the attorney who filed the response for, in opposition to the habeas petition that's over there in federal court, it's a special assistant attorney general, but it's actually one of the attorneys from the Norfolk County District Attorney's Office. Apparently, it's the guy who handled the appeal for the Norfolk County District Attorney's Office. And I'm just wondering if that's any kind of a problem. And I thought about that. And I thought, is it any kind of a problem? Well, it's not a problem from like a conflict of interest standpoint that I can see, like a classic conflict of interest standpoint where, they're different bodies. And so, they might have independent positions on something. No, they got aligned interests in the sense that they both want the judgment of the Massachusetts Superior Court to be upheld. They want the finding that double jeopardy doesn't bar the retrial. They're in alignment on that. But there does seem to be a little bit of a problem in my eyes with the fact that we still have a trial ongoing in the Norfolk County Superior Court. And now one of the parties to that action is the court's lawyer. That seems to be a little bit of a problem to me in terms of just a relationship standpoint. It creates a bit of an appearance of partiality in my mind if the court has a fiduciary relationship with one of the parties with respect to the pending dispute. This seems to me like an issue that's not real hard to spot if you've passed an MCLE somewhere. So I raised this on Melanie Little, and some people caught that and were like clipped it and were talking about that and stuff. And so then out of the blue popped the habeas experts to explain like why it's no big deal because habeas, how this is how habeas is, and this is why the court is the party, and These things that just don't really address the point. It doesn't matter why the court is the party that gets named in the habeas petition. It just matters that the court is the party that's named in the habeas petition, because the court is going to be the one that's subject to any kind of consequences from that habeas petition. If the writ is granted, it's going to limit the court's power to act. Okay, it's going to direct the court to do something. And if the court doesn't do that thing, it's the court that's in contempt of a federal writ. And it's the court that would be subject to some kind of enforcement. So it's not like they're just sort of a nominal party who's kind of there just because. No, they're there because they're the ones that will be compelled to do something if this writ is granted. So, yeah, the court is the party. And it doesn't matter why that came about. The court is the party, and it's being represented by one of the litigants. I don't see how this doesn't create a real problematic situation from the standpoint of the appearance of partiality. Does it mean that this attorney can't represent the court in federal court? No, I don't think that. But I do think it's just potentially problematic for the ongoing prosecution of Karen Reed in this court and or by these lawyers. So I think there is a possibility, there is an option potentially to look at a disqualification of the court or a disqualification of the Norfolk County District Attorney's Office in terms of prosecuting this case. I don't know. Maybe they'll pursue it. Maybe they won't pursue it. Maybe it's an issue. Maybe it's not an issue. But I sure did notice that the habeas experts didn't find me an example where this has happened before, where this is like totally normal and okay. The whole situation is unusual anyway, right? You just don't see a lot of interlocutory habeas petitions based on double jeopardy. Like, yeah, it obviously happens, but you don't see it a lot. So just the kind of thing that I think is a fairly common diversion. Let's ignore the specific detail that's the one that matters. Let's not focus on the issue that counts, and let's try to distract with extraneous things that don't matter. The fact that this guy has published before on other topics doesn't matter. It's not relevant to the key issue. Yeah, it was a great beatdown. That Southern blonde lawyer, Hank Brennan equals Bush League, notwithstanding repping Whitey Bulger. Yeah, he's not impressive. He's not very impressive as an attorney. Not from what I've seen. He's vicious. I'll give him that. He's underhanded. I'll give him that. The whole, we're going down this whole road of having hearings about the defense attorney conduct when he hasn't even filed. He didn't even file a motion. He's just going to drop this in open court and base it on his own representations and stuff like that. Yeah, that's pretty slimy. That's pretty slimy to sandbag like that. So I give him some credit for being dangerous in that type of sense. But it's not a sophisticated danger. It's just thuggish. And that's why, the Whitey Bulger type of analogy kind of fits. He is kind of the lawyer equivalent of that kind of thing. Alessi is in a completely different ballpark. He's not dangerous because he's thuggish. He's dangerous because he's extremely skilled. He's more of, the fencer, more precise, got technique. Yeah, very, very different attorneys. Hank, you can't do that by Bob Alessi is a new member. Welcome to the channel. James Casatelli, it's a real bummer the federal investigation is closed, losing faith in the judicial system by the minute. Well, you notice that Mr. Yannetti didn't fully concede that, did he? He didn't fully concede that it was closed. He said that Mr. Brennan, you know, got his reported receiving this communication. Yeah, maybe he did. Maybe somebody called Mr. Brennan on the phone and said the federal investigation is closed. How did we validate who that was? You know, do we know? Just putting it out there. I do. I still remain skeptical. If all I have is Mr. Brennan's word for it, then I'm still skeptical of that. I'm not saying it's not closed because I don't know, but I'm saying Mr. Brennan saying that somebody told him it was is not, that's not definitive to me. That's not definitive to me. So I still hold open the possibility that it is not closed. But, you know, we did know that Mr. Levy left the office. He's no longer running the show. So it does make sense that there's change of personnel. There's often going to be a change of priorities. We had a whole change of presidential administration, and there's kind of been a lot going on with, you know, what that means in terms of the administrative state and its priorities and its funding and so forth. I'm not going to get into politics and all that, but just observing that is going on. And so it wouldn't really be unexpected either for priorities and stuff to be shifted when you have a change of administration like that. You know, you would want justice to be the driving cause, but the reality is there are a million injustices happening every single day that mostly don't get any attention. And you know, is this one a priority? Should it be a priority? There's going to be differences of opinion about that. Melissa Dotson is gifted 5 more Andrea Burkhart memberships. Thank you, Melissa. You are so generous. Really appreciate that. Track worker. How many times will Bias Bev interrupt defense? She's not interrupting Mr. Alessi very much, is she? No, she's really not. She's going to learn. I think she learned a good lesson today that you want to be real careful. You want to be real careful with Mr. Alessi because you're not going to outsmart him. You're not going to outmaneuver him. He's already steps ahead of you. This guy's a chess master. Now, Mr. Yannetti, she'll interrupt him. She'll stop and ask him questions. Mr. Jackson, I'm sure at the motion hearing tomorrow on the motion to dismiss, I expect it. I do. I expect there to be interruptions. We'll see. We'll see. Tastic. The defense should change up their tactics. They should just infuriate Bev as much as they possibly can and force her to have a stroke. Well, I mean, the reality is that by winning the case, they'll essentially achieve their goal of exasperating Judge Bev, you know, beyond her limits. You know, yeah, good lawyering is the answer. And they have such a strong team now. They have such a strong team. They've got so many different skill sets, so many different resources available. I think they got a good shot, guys. They got so much material to work with. So much to work with. Winning the case is going to be the ultimate revenge. And the reason I love it, you know, I mentioned this on Melanie's show too. I know that it's very disappointing in a lot of ways to have a second trial. It's expensive for Karen. It's, you know, seems unjust in many ways. But there is the upside to it, which is that vindication is valuable, and you get vindication from a jury verdict affirmatively saying you're not guilty. You get that in a way that you don't get if the case is just thrown out because of misconduct. If the case is just thrown out for misconduct, it keeps the door open for the Commonwealth and for critics and all of that, to continue to maintain, well, she's really guilty. She just got off on a technicality. And so that's not fair to Karen. It's really not. It doesn't give her, it saves her money. It takes her out of jeopardy. I mean, don't get me wrong. Obviously, there's a reason why they're asking for dismissal. It's not like it's, you know, no value, but it really doesn't give her the vindication that, I think anyone who truly thinks she didn't commit this crime thinks that she should have and that she should be entitled to. So it's just an even better, even new opportunity that they have to show. Keep pulling on these threads like with the video and stuff and show us. Yeah, these guys framed her, and they keep changing their story and they keep coming up with stuff late in the game. How much more trickle-in discovery are we going to get as the trial is ongoing, long after the Commonwealth has filed their certificate of compliance? Are we going to continue to be getting things from, you know, last year, year before? I'm going to be very curious to see that. Melissa Dotson, Andrea, I told Bob and Allie last night that we'd like a Power Girls panel with yourself, Melanie, and Allie. Dream Team stream. That sounds super fun, honestly. Maybe a smorgasbord of trial talk, Delphi, Koberger, Reed cases. Allie's birthday is tomorrow. FYI, I didn't know that. Thank you for letting me know. I will wish Allie Mata a very happy birthday. Allie was wonderful getting a chance to meet her over there in Delphi. Got to hang out with her and Bob in Chicago as well. She is a fierce one. She is a fierce one. She is an excellent advocate. She is a very creative thinker. That's something that from the defense side, we always find very valuable, because it's those opportunities that you have to develop the law. That's really where you have a lot of room to maneuver as a defense attorney. A lot of times you go and read the cases and they're pretty squarely against you, right? It's already been decided. There's not that many issues that are brand new, although that is kind of changing as technology is changing on such a rapid basis. But so, you know, you're faced with an issue and maybe it strikes you as wrong and unjust and it shouldn't be this way, but you go and look at the case law and the case law seems to be pretty strongly against you. Well, one of the opportunities you have as a defense lawyer is you get to go argue why that is wrong and why that should change, or why it doesn't apply anymore, why circumstances have changed such that a different outcome is needed. And so that's the type of thing that you see, for example, with we saw in Koberger with like the IgG testimony. This is such a new technology. It's completely different from what the court was anticipating back when they were evaluating the constitutionality of seizing DNA and doing this type of testing and stuff like that, where the information that you could get from the gene was very limited at that point. That's no longer the case. They can know almost everything. And so we have to be looking down the road to the potential uses of that information. And it changes the context in a way that calls into question, are those assumptions that case law was based on, are those still viable? These are creative arguments that the defense has to make. Arguments like the whole issue with the warrants for Amazon, for Google, for Apple, that conventionally we had this third-party doctrine that said, well, if it's the business records that somebody else has kept and maintained, you don't have a privacy interest in that. But the world has changed so much in the digital era. We're so dependent on digital information that massive amounts of information about our private lives is stored by Google, is stored by Apple. And so same thing, those underlying assumptions, hard for them to continue to apply in the modern world. And so attorneys have already successfully convinced the court to get off that line of reasoning with respect to certain realms of information, and most specifically with cell location, cell information. A lot of other stuff in there as well. So finding those little holes and being able to think creatively about how to navigate through them or how to convince the court that that situation should change. That's the kind of creative thinking that is so, so valuable in the defense bar. So Allie is an extremely creative thinker, and that makes her a very strong asset as a defense lawyer. Charm Free, thanks Andrea, so happy you're back. Well, thank you, Charm Free. I am glad to be back with all of you as well. Sherry Barros, thank you so much for the super chat. Mathis Grease, to me, the most striking thing about the Commonwealth is the absence of an affidavit swearing to facts, presenting a narrative in the Commonwealth's favor. Just bad facts. Yeah, it is noticeable. It is noticeable how they don't present affidavits. They just present allegation, and they expect those things to kind of be treated as equivalent, and they're not. They're not equivalent. For the Commonwealth to be filing a memorandum where they make representations about Lieutenant Fanning and where he was and what he did and so forth, it's not appropriate. It's not firsthand knowledge, and it's not sworn. So it really isn't something that the court should be relying on in making any kind of decision. And then this other point you made, yeah, they don't affirmatively assert their own position. They just try to smear the defense and get their way that way. And we just had a great example of that with the Dr. Crosby testimony. They didn't, or not testimony, but the argument. They didn't go in and justify or even try to justify why Mr. Crosby has the actual qualifications to do the work and produce the opinion that they want to use. They didn't even try to argue, well, here's why he has sufficient expertise to be able to make this type of analysis. Would have been hard, just based on his experience. He's seen millions of these bites, thousands of these bites. His job is to notice distinct differences between these bites. You can come up with something to say he's the guy who's going to know a dog bite when he sees one. But they don't even do that. What do? They go, but Dr. Russell. Well, yeah, because Dr. Russell is different and she has different qualifications that she brings to the table. And you litigated that and you lost. But that's all they have. They can't rest on the strength of their own case. They have to try to focus on smearing the defenses. And you know what that makes me think of? I mean, that's the whole first trial, wasn't it? That was like the vast majority of the first trial. I kept saying while we're watching this trial, when are we going to get to proving that John O'Keefe was hit with a car? Because that's fact number one that needs to be established for Karen Read to be guilty of any of the crimes that she's charged with, is proving that John O'Keefe was hit by a car. Very, very critical foundational point. And we sat through weeks of testimony about the snow and, Karen flirted with Brian Higgins and just all of this extraneous stuff that was all built around pre-bunking the defense case, pre-butting the defense case. So yeah, it is definitely noticeable. It's definitely noticeable. And, I do wonder to what extent that was effective, because it had the effect in some respects of kind of shifting the burden of proof, making the jury think that, both sides are on equal footing when it comes to establishing what happened to John O'Keefe, and they're not. They're absolutely not on the same footing. The Commonwealth has the burden of proof, full stop. They have the burden of proof. So the fact that they're focusing on pre-butting one possible alternative explanation doesn't mean that they've proven their own. But I do. I'm concerned about that being effective by implication, by suggesting that, well, you know, the defense isn't right, therefore we must be. That's not how the system works. That's not how the burdens are set up. So I just don't know. Oh, it looks like, let me go ahead and share this. We've got a statement now from Chief Rafferty. I don't know if we can see this. Let me see if I can blow it up a bit more. Here we go. Ignore that. Ted Daniel, Canton Police Chief Helena Rafferty just released this statement to the media. As we reported, she was one of the people the feds notified about the closure of the federal probe. I recently spoke to and was informed by the U.S. Attorney's Office that all aspects of the federal investigation initiated by her predecessor and related to the death of John O'Keefe have been completed. The investigation is no longer active and will be closed due to ethical limitations. I cannot comment further. And so there is her statement, dated today, all media outlets. It's a press release. Ethical limitations. Since when do they care about the ethical limitations? She's the police officer anyway. She's not even the lawyer. Well, I appreciate that. So, guess that's our confirmation now. Now we've got Helena Rafferty saying so as well. Well, so be it. What does it mean? It means nobody got charged. It means nobody got charged. If this investigation is what I think many people assumed that it was, inferred that it was, and what certainly seems like a logical inference about what it was, that this was an investigation of corruption, of official corruption, concerning potentially the district attorney's office, the Massachusetts State Police, the Canton Police Department, etc. I can see a lot of reasons why it wouldn't result in indictments that are not because everything here is fine and they didn't do anything wrong. There's always got to be a federal crime. That's, you know, part of the issue, part of what they're dealing with. And with federal crimes, federal corruption crimes, like official corruption, one of the big problems is that you're dealing with benefits. You're dealing with quid pro quo types of situations, that they are not just exercising their discretion that the law gives them, how they think it should be exercised, but they're doing it because they're getting something. They're getting some personal benefit for it. And so these types of relationships, this type of corruption, it's pretty easy to demonstrate when you have like financial relationships and clear evidence of quid pro quos, things like that. There was a case I saw maybe within the last year or two that was down in Hawaii. I saw it because the Department of Justice issued a press release about it when they indicted the prosecuting attorney, I think in Honolulu, for basically going out and prosecuting this guy, like, you know, fabricating evidence and doing things like that to prosecute this guy who was involved in like some type of family dispute, custody dispute with members of her family or something along those lines. So that's a situation too, where there's not a direct financial benefit, but there is a personal benefit that can really be fairly clearly established. This is going to her relationships and her personal interests. It's really hard to do that with a good old boys club, right? Where it's just more amorphous than that. It's not that we do things because we have a specific expectation that we'll be paid back for it in the future. We do it because that's what the system is. We do it because that's what the system is, and because we know, number one, if we don't do it, now we're on the outside and we're at risk. We're not part of the club. And that can be a dangerous place to be. But also, you know, I'm not going to necessarily have a specific expectation of a benefit, but it's just a general, you know what, when I need it, they'll have my back. When it's important that I don't take any heat because I'm a Boston police officer, that was never promised to anybody. I'd be pretty willing to bet on that. That's never like specifically laid out there as some kind of expectation. No, it's just a fully corrupt system that's self-perpetuating. So it's going to be nearly impossible to prove that quid pro quo, that personal benefit in those types of circumstances. That can certainly be a reason why a federal charge wouldn't go forward. That doesn't have anything to do with, was there lying? Was there dishonesty? Was there fabrication of evidence? Potentially. But those aren't necessarily federal crimes. So we'll take it on faith now. There's been a press release from the chief of police confirming she heard from her source, the U.S. Attorney's Office, that it is over. So I'll buy it now. It's over. The significance of that? Questionable. John Beattybot, fair remedy to accumulated Commonwealth nonsense would be inverted video plus zero metadata along with all chain of custody equals exclude the taillight, not just video. Yes, that would be a potential remedy, is limiting the use that the Commonwealth can make of the taillight evidence, because they have deprived the defense of the ability to be able to investigate it. So they have set the stage in such a way that their version of events can't be meaningfully challenged. And not just because of circumstance, but because of choices that were made along the way to not preserve the evidence, to selectively, disclose, to handle. Apparently, from what we hear at the end of court today, they already did the drag and drop the file things to produce the videos to the defense. And what we heard from the defense's expert, that's going to delete the metadata. So they've had these choices all along, and time after time after time, they've chosen the one that gets rid of information that, if it were available, maybe it would verify. Maybe it would verify their version of events. Maybe it would, but we'll never know, will we? So we'll never know if it would contradict it, or if it would show that they were telling the truth. And so why should they get the benefit of all of those choices? That would certainly be a remedy. Commonwealth, you don't get to rely on the taillight. Is Judge Bev going to give them that? No, I seriously doubt it, because frankly, I think even getting a spoliation instruction is going to be a challenge with Judge Bev. The spoliation instruction is a jury instruction. When one of the parties has withheld or destroyed evidence, and as a result, that evidence is not available to the jury, and, they had the unique ability, it was in their possession, they had the ability to make decisions about what was going to happen to it, and they chose to destroy it. There's an instruction that can be given to the jury that says, you can infer from that the reason why it's not available as evidence is because it was negative to the party who had control of it. It was contrary to their interests. It didn't show you what the Commonwealth wanted you to think. That's why they had to get rid of it. It's essentially what the instruction says. To me, that is the bare minimum that they should get in this case. There's just too much sketch going on here, too many unanswered questions about why do we selectively only have certain pieces of video, certain pieces of time frames within that video. Certain angles, perspectives, some of it's been kept, but some of it hasn't. And we still don't have a good explanation for who and why and how any of that took place. The Commonwealth should not get the benefit of the doubt from all of this. So yeah, from a bare minimum, they should have the spoliation instruction, because all you had to do was preserve the metadata. That's all you had to do. That's all you had to do. The thing that shows that what you're presenting as evidence in court is authentic. All you had to do was preserve that. And you got digital forensic people on your own staff, in your own department, working for you with your ISP. Those people can tell you what needs to be done to preserve the metadata. So it's not like this came as some mystery. No, that's a pretty fundamental part of digital discovery. So why isn't it there? Fair argument that we should draw that inference against the Commonwealth. The reason why it's not there is because they don't want us to see it, because it makes them look bad, and it makes their case look bad. But are we even going to get that instruction from Judge Bev? We'll see. I've kind of held out the possibility that might be her. That might be her, magnanimous gesture to sort of demonstrate that she's taking this very seriously, and she's very fair and even-handed, right? She's being very fair to the defense, giving them this remedy. Because at the end of the day, the problem is that the defense can argue that anyway. They can always argue it as an inference from just the facts that we have and that we know. So does it add anything significant? Not necessarily. Maybe marginal, having it in an instruction from the court maybe does give it a little bit more weight than when it's just use your logic from the reasoning that the attorneys are giving you in their arguments. So maybe she will, because that'll make her look very fair. And the next time, people are arguing how unbiased or how biased she is and how the standards don't seem to equally apply to both sides, she can point out, I ruled in favor of the defense. Look at that. I even gave them a spoliation instruction. Whatever clever. Thoughts on second trial proceeding before habeas? Well, I do have some thoughts about that. I have mentioned before, I don't think that the habeas petition stands a particularly good chance. It's just not on very strong law. I was talking very briefly at the beginning kind of about that, the context. The Bluford case is the one that's most problematic for their position because it deals with a very similar set of circumstances where you had a jury in Arkansas that acquitted the defendant on certain lesser included offenses or greater offenses, but couldn't reach a verdict on the lesser. And the court declared the mistrial. And the question is, does the defendant get to be retried on all of those charges? And the court said yes, she does. Now, some of that can be tied down to some specific idiosyncrasies of Arkansas law. When it comes to handling lesser included offenses versus a greater offense versus different separate charges in an indictment. So there's, room for the defense to maneuver and make an argument around it. But that's still just not a very good position to be in. The court did use some very broad language in saying things like the trial court doesn't have a duty to inquire about were they able to reach a partial verdict or anything like that? So they're not on a very strong legal footing. I think that there are and were potential ways to, again, part of a defense attorney's job is to think creatively about why the law is wrong and why the law has changed. And one of the big problems I have with this whole reasoning is that it gives this power to the state to define what a verdict is, right? Because we defer to Massachusetts law that says Only when it's read and affirmed in open court do we have a verdict. That's a matter of state law. That's not a matter of constitutional principle. And so it seems a little bit strange to me that the scope of a constitutional right, meaning your right to not be retried on a charge that you've been acquitted on, that's just subject to the whim of the legislature. Because what limiting principle do we have to be able to say that the legislature can't say that the verdict then also has to take a specific form and the verdict has to be announced by a particular person? Like, you could potentially just bureaucratize that decision down to the point where, you know, there's almost no verdict of acquittal. It doesn't make sense. The legislature doesn't have the power to take away your constitutional rights by, you know, procedural statutes. So that, I think, is part of the concern. Why is this issue not constitutionalized? What constitutes a verdict, as opposed to just something that's subject to the whim of whatever state legislature that we're in? The argument didn't get raised. It didn't get raised in Massachusetts. It's not a good argument for habeas for a lot of reasons. Number one, because it wasn't raised, it wasn't exhausted, but also because habeas is typically going to involve things that are clearly established. They're not going to, you know, say that there's like a new rule of law that the court, you know, should have applied. The court wouldn't know. Like, that's not really the posture that you're at in a habeas situation. So I don't really have a lot of optimism about the prospects for it. However, I will say, having gone through and read the petition and the memorandum, the argument on the manifest necessity, definitely a lot stronger, it seems to be, under the federal law than under the state law. And, you know, the Massachusetts court made certain findings and looked at the process a certain way that was, you know, clearly very sympathetic to the trial court and in some ways kind of, you know, pragmatic. I mean, in many ways it was fairly pragmatic. It's true that the defense wasn't like arguing against a mistrial. It's true that the defense didn't stand up and object at any point. Honestly, is it a fair question whether the defense would have opposed the mistrial had they been asked? It's a fair question. Because you don't typically ask for something like the Tui Rodriguez instruction unless you're angling for that. You know, you want that to be on the table. But that's not necessarily the standard that gets applied in the federal court. You know, they look at the options that are available to the trial court. Did they get exhausted? There was some precedent that the court relied on, or, you know, some precedent that the parties relied on that dealt with, you know, cases that came up through the federal courts where, like, it's fairly equivalent in terms of, did you really, you know, there are options. Maybe it's questionable whether they're really options, but you didn't even explore them. The one, was it Castaneda Lopez, something like that? There was this one case that involved a situation where, I got to try to remember the details now off the top of my head. I just read it a couple days ago. But basically, the problem was the bailiff came to the court and said, there's a juror missing. There's only 11 people that showed up for the jury. The law in that jurisdiction allowed the trial to go forward with less than 12 jurors if the defense consented to it. And so the judge asked the defense, do you consent to that? And she says, the attorney says, no, we'd rather wait for a full jury to show up. So basically, like, wait for the 12th juror to show up. The court then finds out from the bailiff that actually this juror has been gone. This isn't the first day the juror hasn't shown up. The juror hasn't been there for any of the evidence. So, like, all of the evidence that's been taken in the case so far has only been heard by these 11 jurors. And obviously the defense had not previously consented to that. So the court says, well, look, you know, we don't have a 12-person jury. We haven't from day one. I don't see how this is curable. I'm declaring a mistrial. That got reversed on appeal on a finding of no manifest necessity because she didn't ask the defense attorney if they were willing to continue under these circumstances, like with this knowledge. Now, do you want to still go forward? Because the court considered that preliminary decision, that preliminary answer, we'd rather wait for the full juror. Number one, it was conditional. It wasn't like a flat out, no, under no circumstances are we going to consent to a 12-person jury. But also it was just based on the information that was known at the time. And, once the information changed, implication was basically you needed to go back, you needed to flesh this out, you needed to make a good record of what the problem was, what options you've considered. Has the defense really and truly taken this off the table? You kind of inferred that they did, but you didn't ask. That's a very, very strong case for Karen Reed in this context, because it's very much equivalent. They assumed that the defense wanted the mistrial. They assumed that they didn't want any other type of remedy, but they never asked. She never asked. So I do give them, I think, slightly better chances of possibly winning on that issue. But it's still not great. They're not in a great posture. You're never in a great posture when you're asking for habeas. And a lot of the reason for that is because it is such a technical process. You can see that if you've read through the pleadings and stuff, the response that, the attorney for the Commonwealth representing the court filed. Very, very common way of responding to habeas types of actions is to argue the procedural limitations, right? And so they focused a lot in their response on, well, you're bound by the interpretations of state law that are handed down by the Massachusetts court, and you're bound by the factual findings of the Massachusetts court. And so given that, you can't really get out of the reasoning that the Massachusetts Supreme Court followed. And, from the procedural standpoint, courts love those, man. They really do. They really do. There's just in general, as a matter, not a matter of law, but just a matter of almost like comity, almost like just respect, trying to restraint, judicial restraint. I'm not going to interfere with other courts unless it's like really, really bad and really, really obvious. So the federal court is going to be disinclined to come in and tell a state court what to do. That's just the culture that you're kind of coming into and that you're going to have to overcome. And that's, one of the reasons why I think they're just at a disadvantage here, even though they do seem to have some pretty good law to rely on the manifest necessity issue. So that was a bit of a tangent, but just a, context to give you kind of my thinking about the habeas petition, because it does seem to me to be fairly unlikely that the writ is going to be granted. Nevertheless, it isn't impossible. And part of the problem we have here is that if the writ is granted, then we're not going to have another trial. At least we're not going to have another trial on murder. We're not going to have another trial on count 3. The manifest necessity arguably should also cover count 2, because if there's no grounds for a mistrial because you didn't adequately explore whether a mistrial was necessary or not, that doesn't go to the substance of what the jurors did in their deliberations, whether they did or did not acquit her. It's a different problem. So it should theoretically apply to all 3 charges, but they didn't raise that. They didn't ask for that in the Massachusetts Supreme Court. And so once again, we have a problem. It's not exhausted. They can't present a new argument on a writ petition that they haven't already presented to the Massachusetts Supreme Court. So based on that, even if the writ is granted, I think trial still gets to go forward on count 2. Because it wasn't part of the remedy that they asked for. So that's sort of where I'm at with it. I don't think that it inherently stops the trial from going forward. Even if the trial did go forward and the writ was granted, is that like an irredeemable injury? Well, it would be if all of the charges were on the table, if she wasn't supposed to be subject to a new trial at all. But that doesn't seem to be the remedy that they asked for. So she would be going back to trial on count 2 anyway, even if a writ issued and said, yeah, for whatever reason she can't be retried on counts 1 and 3. So it's not going to stop the full trial anyway. So for that reason, I mean, I think it would be smart for them to wait and see what the outcome is. It sounds like the federal court is inclined to accelerate its own process. It called for accelerated briefing. It's having the hearing tomorrow on very short notice. So we may get a decision before April 1st. It acknowledged the time frame when it did the acceleration. So maybe that's the plan. That's the best case scenario, I think, just so that we know what's the playing field that we're dealing with. You do kind of take a different approach and set different priorities with a charge of manslaughter than you do with murder, just because the consequences are so much different, But it just affects your strategy in terms of, acknowledging what the Commonwealth has to prove. Manslaughter has always been the much smarter charge here than murder, because proving a deliberate, we're having a hard time establishing that there even was contact with the motor vehicle and with John, let alone why and how that took place. So proving that was intentionally done is challenging. It's challenging. And so manslaughter has always been the smartest argument. They were drunk. Maybe she didn't know. Maybe she just backed into him. Maybe it was malicious, but we can't prove that. It's always been the smarter argument. And it's a harder one to defend, because they do have to really focus on that technical point that you got to kind of prove a car accident first. So your defense strategy has the potential to be different. It would be smart for everybody to know this is what the playing field is. This is what we're going forward on. These are the ground rules before you actually get underway. But if they don't, is it the end of the world? Is it a grave injustice? Probably not. Probably not, because the reality is we're going forward on manslaughter no matter what anyway. James Casatelli is back as a new member. Welcome back, James. Glad to have you back. Peter Archer, words matter. If Chief Rafferty's statement is accurate, and the U.S. attorney stated their investigation into John O'Keefe is closed, there is no mention of Karen Reed, Northup District Attorney's Office, fraud, or civil rights violations. That's true. That is true. It could just be that the John O'Keefe part of the investigation is closed. But we also don't know, because we don't know the broader investigation, the scope of it. We don't know what other investigations are implicated. There's certainly reason to think that Sandra Birchmore is one of those implicated investigations, because once again, same people were involved. We had that determination that it was suicide. The family challenged that. They filed a civil suit. There's a medical examiner that finds it's homicide. They find that, there's been these 30-some thousand text messages that somehow Trooper Guarino managed to not see on Matthew Farwell's phone. And now we have a criminal. We have a criminal prosecution of Matthew Farwell by the feds. So yeah, there's kind of reason to think that there's maybe some other investigations that relate to the overall, if it's a corruption probe, the overall corruption probe. So yeah, it's possible. Now, does that really help Karen Reed in that sense? I don't know. I don't know if they're saying the investigation into John O'Keefe is closed, and at least the implication is, here's another thing where words matter. The investigation is closed. Okay. Does that mean that the entire process is closed? Does that mean that there's no grand jury? Does that mean that there's been no indictments? Sometimes indictments are issued and they're sealed, while other things are going on. I agree with you. The statement doesn't take any of this stuff off the table. So it's very hard to know without the DOJ telling us personally what's going on here. It's very hard to know what the significance of this announcement is. I still come back to that federal protective order. And so if now, since the end of February 18th, 20th, something like that, 19th, when Mr. Brennan said he got that phone call. Okay, it's been a few weeks now. He waited a week to tell the defense. Not real clear why that was, but he waited to tell them. And now it's public in open court. So it's been several weeks that investigation has been concluded. So the investigation is no longer going to be jeopardized by those materials that are under protective order, at least not for the reason that the investigation is ongoing and, it could clue people in, or whatever. So what's the justification for that protective order continuing to be in place? Is it going to continue to be in place? Are we going to go back to federal court now and ask for it to be modified? Does it expire? Is there language in this order? I don't know. But it's a loose thread that's hanging out there that's got some pretty significant implications for this case that for me is a little bit hard to reconcile with everything is totally over. This whole investigation is totally over and nothing is going to happen as a result of it. Just seems like if that's the case, we're going to have at least a loosening, a relaxing of the protective order, if not a complete release of it. So I agree, words matter, and statements are wordsmithed. They're done on purpose. And if they've known this for these many weeks, they've taken a lot of time to think about how they're going to word this statement. Alessi, the lovable law hobbit. Gosh, he does look a little hobbit-like, doesn't he? How are the doggos? Do you know how to crochet? The doggos are wonderful. They were very happy to see me. I was happy to see them. The first time I was gone for 3 weeks or something like that. The first time I went to Chile last year, when I came home, it was the longest I'd ever been away from home. And Buffy, the pup, she's not really a puppy anymore now. She's like 3, but she's the baby. She was scared when I came home. Like she thought I was a ghost or something. And it made me feel terrible because it was like she'd given up hope on me coming back. And so then when I was actually there, she didn't really believe it was me. Like she came out on the porch, she had her tail between her legs and she was like trying to hide behind Jeff. She didn't really know what to make of me. But now she's over that now. I was, gone for much longer time this time. And I think she has now the mature dog sensibility that mommy will come home. She's not gone forever. It will all be okay. You just got to be patient, good dog. So she was very happy to see me this time. I do not know how to crochet. I did learn how to knit when I was young, but I really didn't enjoy it. I suppose I could try again. I do like the look of crochet, honestly, more than I like most standard knitting. I have a cousin, my cousin Molly she's a phenomenal artist and she really focuses a lot on textiles and on sewing and crocheting and things like that. She's working on a project now that involves a lot of crocheting. So I definitely have resources, excellent resources I could learn from. And maybe I will pick it up. You know, I always like new hobbies. But no, as I sit here right now, I don't know how to crochet. Melissa Dotson, for Jeff, great people always have great support systems and most go unnoticed. 100%. You're rock solid. I did not consult a meteorologist to determine how hard. We don't want to get the chat going too much on Jeff's hardness. Okay, that's, I'm just here to tell you right off the bat, that's a little bit of a dangerous territory. But he is my rock. Not in the rock hard sense, but just in the support. 100%. I agree with you. I couldn't do anything that I do without him. He's, my partner. He's been a huge part of my life. We were law partners for, many, many years before we became home partners and YouTube partners and stuff like that. So thank you very much for that, Melissa. It's very generous of you. And I always like to give Jeff the shout out when I can, because he really is essential to the whole undertaking. Z, any thoughts on Turtle Boy's juror interview? Well, I want to do a video on it. I haven't watched the whole thing yet. It's a little bit lengthy. And for those of you who have watched it, you have already seen it's a little bit aggravating. So kind of need to pause from time to time. But I plan to do a video on that because there's always good things to learn from juror interviews, Jurors don't think like lawyers do, and it's very easy for lawyers to forget that. Just time after time after time, when I've had a chance to talk to jurors about their decision, why they reached it, what was important to them, it's just often stuff I never would have thought of. I just didn't see what it has to do with anything. Sometimes I don't follow their train of thought, even when they're telling me what it is, But that kind of thing is just, it's important to bear in mind, because that is kind of your average lay expectation and perspective. And you have to be able to understand that if you're going to understand what will move it in your direction. So always a ton to learn from juror interviews. That's kind of the eye that I'm, trying to take to it. I will tell you, I guess, just as a preview, this is something that's been well studied and well established, and hopefully maybe something that the defense is able to work on a little bit the second time around. Jurors struggle with reasonable doubt and with burdens of proof, with the presumption of innocence. These are things that they struggle with because they're not intuitive. And there are so many ways that the trial can unfold that just invite them to shift their thinking about those particular issues. So that's one thing that has definitely caught my attention that I'm kind of probably going to be focusing on. They really need to work on reasonable doubt and what that means, and reminding the jury the Commonwealth is the one that has something to prove here, not the defense. The defense doesn't have the burden of getting up and presenting you the entire universe of possible alternate theories of how this happened. They don't have that burden. And that's what placing a burden of proof on them implies that they would have to do. Because they would have to come up with some alternative, explanation that can be proven beyond a reasonable doubt. That's not their job. If the Commonwealth hasn't proven it, she's not guilty. So it's their version of events that the law requires that you put under the microscope. Now, and it's hard when you have a time-limited closing argument, especially a pretty small, short period of time for a trial that went on weeks and weeks and weeks and heard massive amounts of evidence. You have to prioritize. I don't like time limits on closing. For all that, you should be able to get to the point and refine it. You don't want to ramble and talk about everything. You do need to be focused. And that does mean there will be some things that you don't talk about because they aren't essential to being able to make your point. Nevertheless, having time limits on closing, I don't like it. It's arbitrary. But if that's going to be what they're stuck with, then yeah, you do. You have to make priorities. And so that's part of where this type of information can be really helpful, is just identifying what your priorities should be. What do they need to be for the jury to be able to see things your way and reach the conclusion that you want them to reach? Z, don't feds have separate investigative grand juries and indicting grand juries? They only ever mentioned an investigative grand jury, so only that closed. Maybe. They can have both. I mean, a federal jury, at least my understanding, a federal grand jury that's considering indictments still has investigative powers. But they can, yes, the feds can convene a special investigative grand jury that's just for purposes of getting information, that's not anticipated to return any kind of indictment. So yeah, I mean, while we're getting into the wording of this announcement and the significance of what it actually, very hard to say until we hear it from the horse's mouth. We don't really know what that means. Sandra M with a super chat. Thank you so much, Sandra. Really appreciate that. Desert Cat, been a live trial watcher since the Sleepwalker murder in 1999. Have never seen so many different kinds of shadiness from so many on the Commonwealth side. You? I mean, you know, OJ wasn't great. Does it reach this level? Not really. Not really. Delphi. Now, Delphi's got some real shady stuff. I mean, these cases often are getting kind of held up side by side, and there are so many commonalities between them. Commonalities between the judges, commonalities between the prosecutors, the attitude, the lack of transparency, the withholding, a lot of similarities. I gotta tell you guys, may not be popular right now in the context of this show. We're not at Delphi levels yet. I mean, that is some of the worst. Just lacking in integrity at all levels that I have ever seen. I know that Judge Bev is really not ideal. She's got a lot of room to improve as far as being fair to both sides. She doesn't approach the pure malicious evil that was Judge Gohl. Just not even in the ballpark. My opinion. Just my opinion. So, I mean, you don't want this. You don't want this to be the thing, but at the same time, I mean, how many times do we have to hear about rampant prosecutorial misconduct being a thing before we accept that it happens all the time? It just happens all the time that they hide evidence, that they cover things up. The reason why this looks so shady right here is because they haven't been able to cover their tracks. That's why. It's just because there are threads to pull. If they'd never produced any of that sallyport video, would we even know that it existed? Would we have even gone down any of this road? You know, is the Commonwealth's problem here just that they weren't sketchy enough? I hate to think about that kind of thing, but that's just sort of the reality of the system that we deal with. You know, when you have your Kevin Kleinsmiths that can lie, fabricate evidence to get a FISA warrant on a U.S. citizen, and that attorney gets slapped on the wrist and gets a, brief period of not being able to be a lawyer, and then gets reinstated and is now back in good standing in the DC bar? That's a broken system. That's a system that is not prioritizing integrity. And so if the system doesn't prioritize integrity and it doesn't incentivize integrity, then you're not going to get integrity. So I agree with you. It's very rare that we get to see this stuff so overtly. But it's just a tiny, tiny percentage of trials that we get to see, that we get to live watch, that get publicized. So it'd be nice to think this doesn't happen very often, but think of this as our sample. You know, it's not even 1% of trials. It's a tiny percentage of trials that get televised that we get to live watch. And we're seeing this over and over and over in these cases. Yeah, it happens a lot. It happens a lot. So yeah, this is particularly shady, but I'm not prepared to say that that's because the Commonwealth is particularly egregious here, and not because the Commonwealth is just particularly stupid here and they didn't hide their tracks well enough. So we're able to see it more overtly. Sandra M., this case gives me an ulcer. Chile is the best. El mejor. Chile es el mejor. It is the best. I really do love it there. Recommend it to everybody. There's just so much to like. I really enjoy it. I enjoy the culture. I enjoy the climate. I enjoy the history. Chile, I'll tell you my final little rant that I'll go off on about Chile. In many ways, it doesn't have this reputation at all, right? America is known as like the great melting pot of the world. We welcomed all this immigration. We managed to integrate everybody into a coherent society, cohesive society. We all get along and so forth. Well, that's kind of the American dream story, right? And if you kind of look around today, I think there might be some reason to call that into question about how successful that is. We are, in fact, actually very balkanized and very polarized, and, you know, a lot of tension along racial lines and along cultural lines and so forth. Maybe we didn't melt as well as we think we did. Chile is a melting pot country. And in many ways, I think, much more successful than the United States has been. One of the things I really enjoyed when I was in Punta Arenas, which is down in the very southern part of the country, it's on the Strait of Magellan. And so it's, you know, one of the earliest areas that was colonized by Spain, Portugal, and has kind of been, you know, civilization there. And obviously there was civilization there before, but there's been modern civilization there for centuries now. There's a church there, a big Catholic church, and it has a big cemetery, and they have the culture of the big family mausoleum, right? So it's like a big building that houses the branch of the family, and it'll have the family name on it, and, you know, multiple people from that family will be buried there, and then, you know, descendants will go and visit and show their respects and so forth. Cool thing about the Spanish naming conventions, right? The Latino naming convention includes both the father's last name and the mother's last name. And this causes a whole bunch of chaos. I can just tell you, like, anecdotally, in U.S. record keeping, because we don't really know how to deal with that. Our version of the last name, you know, the last name in the line is the father's last name, the family name. And so that's what you're known by. My name is, you know, Andrea Burkhart, and Burkhart comes from Jeff, and Jeff got it from his dad and his dad and so forth. Same thing in Spanish. You are known by your family name. That's what people are going to refer to you as. Your father was Jose Hernandez. You are Jose Hernandez. The difference, though, is that your mother in the Latino countries, your mother's maiden name gets added on to the end of your last name. And it's just a way to kind of track the different branches of the tree. And so you know that, like, in your line of Jose Hernandez's that all descend from the same grandfather, this Jose, you know, the original Jose Hernandez is going to have another name of, you know, Magdalena. That was his mother's maiden name. His son is going to have Jose Sr.'s wife's maiden name. So that will be Jose Hernandez Perez, you know? And so it just gives you this way to be able to see the way that the family has spread out over time with the different generations and distinguish the generations. It's a mess with record keeping in the US because we've never figured out how to deal with this. The fact that the last name in order in the Latino naming convention is not the family name. It's not the one that they're known by. So when you go and look in like some of the records databases, the court records, the Department of Licensing records, things like that, it's a freaking mess. Sometimes the person will be under their family name. Sometimes it will be a hyphenated name. Sometimes it will be under the mother's, the mother's maiden name. It's just a disaster. I don't know why this is so hard for us to just figure out a consistent way to incorporate Latino naming conventions into our databases, but we haven't. Anyway, the reason I brought this up is because you can then see how the family lines evolve over time in this cemetery by looking at the mausoleums. And one of the things that you would see is this melting pot of names. You would see Hernandez Mueller, from like when a lot of German immigration. There was a period where Punta Arenas got a massive amount of immigration from Czechoslovakia. So there's all these Czech names that I'm not even going to try to pronounce. But it would be, the family name on the mausoleum is Garcia, whatever, Svilicic or something. I'm just saying, I don't know. It's kind of what it looks like, but I have no idea how to pronounce these things. So you can see the melting pot happening in this cemetery just by visiting and the different areas and, what era was this part of the cemetery, developed and all that type of thing. So they have that same kind of history that we do of not really being a country that is unified as a country because of ethnicity. It's not that we all come from the same ethnic background. They have a very mixed ethnic background and a very mixed cultural background. And yet Chile is still one of the most patriotic places I think I've ever been, like far more than the US. We certainly have a very patriotic element in the United States, but it's not universal. Chile, it's pretty much universal. Like every Chilean loves Chile. And they love that you love Chile. They're very proud of their country, as they should be. It's a wonderful country. There's so much to love about it. So anyway, that's just one of the things that I really enjoyed about my time down there and about experiencing that particular culture is it is an example, I think, of a successful melting pot that has become a country that has a sense of pride in who it is. But that it's not based on things that are divisive. It's not based on, because we're all this religion or we're all this color or we're all this background or we all do the same thing on Sunday, stuff like that. It's not based on that at all. It's just we're all Chilean. So, great place. Highly recommend it. Erica M. Feds don't announce to a local PD when their investigation ends. It's entirely possible something came of it, and that's why Rafferty knows it's over. Well, maybe. I mean, I talked about this at the beginning. They do have exceptions in their policy for when they can disclose the details of the investigation, and one of those is when it's already public knowledge. It's already out there. The public's become aware, and so it kind of allows that shadow that's cast by knowing that there's an investigation that's going on, if you don't clear that up. But, I do. If that's the type of thing that we're relying on, it just seems kind of weird that we're not hearing it from the horse's mouth, that we're getting this secondhand report to a law enforcement officer who was not a partner in the investigation. Why would only the Commonwealth and its representatives be told about this? Why would Karen Reed's team not get a similar call? I mean, they have essentially the same standing with respect to this federal investigation. meaning they're not part of it. Neither of them is part of it. But they have both certainly become aware of it. They've obtained information and evidence as a result of it. I don't know. I don't know. There's definitely some room to still be skeptical. AKA the cat lady, even Turtle Boy's motion to dismiss has been affected by Bev randomly impounding indiscriminately. Check out the motion to dismiss. It's fire and crosses over with Karen's case. Yeah, I have heard about the motion to dismiss. I would like to check it out. I haven't been, I'm aware of Turtle Boy's cases. I have been interested in them, certainly from the First Amendment standpoint. That's the first time I remember wrote the investigative report in Turtle Boy's case, and it's like a 30-some page report, and it's far more detailed and shows a lot more care and concern in that investigation than they ever showed to the investigation of John O'Keefe's death. So I've been aware of it for a long time. Obviously, significant First Amendment implications from that prosecution, but I haven't seen the motion to dismiss. If Bettero's on it, if Mark Betterow is involved with it, I expect it to be quite good. So I will keep my eyes open and see if I can find that. Take a look. Erica M., we all have local courts. We should audit those courts where possible. Audit those cases where possible. That's how this blew up. Like Turtle Boy or not, he was watching his local courts. 100%. 100%. The courts fly under the radar so frequently because there's just not that many people who sit in court and watch. Lots of people go to city council meetings, planning commission meetings, legislative sessions, stuff like that, and observe that part of our government process. But the ones that we're most directly involved in, the criminal justice system, even the civil system, the family system, all that stuff, we just don't have the same type of monitoring. For whatever reason, I don't really know why that is. So I'm 100% in agreement with this. Eyes on the courts they're critical. They're critical. This is a whole branch of justice, of government that's happening, that needs to be transparent. We need to understand it. We need to see what's going on. We need to see if we like what's happening. It's kind of a old observation. We have judicial elections in Washington. I understand they don't do that in Massachusetts. They do appointments. So in that respect, it's a little bit of a different situation. But we have judicial elections in Washington. But at the same time, it's almost kind of pointless because nobody knows why you should elect a judge. The judicial elections are nonpartisan. They don't have a political party, so you don't vote by, just down the ballot. These people. This is my party. These are who I vote for. This judge is there. Judge doesn't participate on a partisan basis. So it's just notorious that people don't know who to vote for or why. And this is a big reason why, because there aren't eyes on the court. I will get people every single election cycle. Just because I'm a lawyer, Andrea, we don't know who to vote for judge. Who should we vote for? It should be more than the lawyers in the community that are aware of what's happening, that know this is the disposition of the courts. These are the decisions that the court is making. These are the decisions that the court has made that have been overturned. We shouldn't just be dependent on the media to tell us when and if they think something is newsworthy that happens to involve a court. So we're all busy. I know we have very busy lives and not a lot of time and not many priority. It's not always going to be a priority to go down and sit in the courthouse. And it's not going to be something that everybody has the luxury of time and energy to be able to do. I fully recognize that. But just where we can, I definitely encourage it. Get to know your local court. Get to know your local court. AKA the Cat Lady is a YouTube member. Welcome. Welcome to the channel. John Beatty Bot, why would DOJ only inform Commonwealth? Yeah. I don't really see why that would be. I don't really see why they would only inform the Commonwealth. Now, we didn't have anybody from the defense team affirmatively say they never called me. They might just not mention that they got called. Suppose in fairness, I can't rule that out. But yeah, this is questionable to me. Why would you just call the Commonwealth and let them know? Why would you call the prosecutor and the chief of police? And those are your mouthpieces? Those are your mouthpieces. Oh, I don't want to get conspiratorial, guys, but we are thinking about possibilities. And so I'm not saying any of this stuff happened, but we are thinking about possibilities and just interpreting the facts as they've been presented to us. Well, here's a fact, guys. Here's a fact. Law enforcement, they're allowed to lie. They're allowed to lie to further their investigations. We know that. We've known that since Frazier versus Cupp. Back in the 1960s, the U.S. Supreme Court said it's totally fine to lie to people in their interrogations. And we have since learned an awful lot more about the pervasive negative psychological impact that can have, and the effect that can have on the reliability of information that you get as a result of lying to suspects. That's, in the context of an interrogation. But it's on the table. It's allowed. And there can be a lot of reasons why you might do that, including, why don't we put them off their guard? Hey, guys, if they think the investigation's over, maybe they'll all run and text each other. Maybe if they think the investigation is over, they'll stop watching their backs so closely. It's a possibility. I'm not saying that's what happened. But I don't see how you can rule it out until we hear it from the horse's mouth, from the Department of Justice, press release or something like that. I think we're justified in remaining skeptical, and we're justified in questioning the truthfulness, and we're justified in questioning the significance of what does it even mean? What does that even mean? Yeah, the words do matter. Curiouser and curiouser. All right, guys. Well, that was fun. It was fun today. It's good to be back. I like to be back on a day where Alessi's letting his hands go. Letting his hands go. Oh, I enjoy it. And we're going to get some more of that tomorrow too. So, didn't get to the motion to dismiss today, but we are going to get to it tomorrow. Plus, we have the added bonus of we are going to get more from Mr. Alessi on the Daubert motion that I don't know what it is. Haven't seen it. I'll keep my eyes open and see if anybody has located that one. But apparently a Commonwealth neurologist that don't know what he's going to say or why there would be a potential Daubert challenge to it. So I would like to see if I can find that out before we go into this hearing tomorrow. Guys, this has been fun. This has been awesome. Really enjoyed it. Really glad to be back. Really glad to be back in the saddle. And there's going to be a lot. We already know in this case alone, there's a lot that is gearing up in a very short period of time. This hearing tomorrow, we were originally set to have one on Friday. Now it sounds like maybe we won't, but we've got the motions in limine coming up. Can't believe that's not going to be extensive. There'll be hearings on that, on the 18th. And then we're getting ready for trial. Then we're starting trial on the 1st. That's just this case. We've had so much go on in Kohberger. Oh, I'm behind on Kohberger, guys. Those of you who are following that case, my apologies. I am going to do my best to get caught up. I have gone through the rulings on the motions to suppress. Don't necessarily have a ton to say about that, except I find it disappointing. I find it a little bit validating in a way that I don't enjoy, because I didn't want the whole concern about if you move the venue, you risk losing the judge, and you might not get a judge that's going to be as sympathetic to your position as the one you have. Ugh, I kind of feel like that's the situation that we're dealing with. Judge Hippler is going to give every single benefit of the doubt to the state. It's very clear. Very clear. He's going to defer to them factually. He's going to find them and their witnesses credible. And when there's an open issue of law, or, you know, one of these holes that we're exploring, he is going to interpret that in the way that benefits the state. He's going to leave it up to the Court of Appeals to say, no, you're wrong, and actually something that benefits the defendant is the right outcome here. It's just so unfortunate, but I'm sorry. I'm from this area. I practice in this region. I know the culture. I knew that was a risk. And I know this judge. I don't know this judge personally. I just mean generally speaking. There's so many judges like this in this part of the country. So, yeah. You know, every single justification pretty much that the state offers, he adopts as his reasoning. That means I'm very concerned about the motions in limine, which is the next thing that's going on. They have been filed. I'm still working my way through those. There's going to be responses. There's going to be hearings on it. I'm going to do my best to get caught up on that and get some content out about that and where we stand before we're actually, you know, getting into the court process. Because I think that's going to be, isn't that going to be after this trial starts too? I think it's like the first Wednesday in April or something like that. There's going to be scheduling conflicts. So anyway, I've got catching up to do on Kohberger, but I just want you to know that I am working on that, and I will be coming up with some stuff. I also, guys, there was something that came up in that transcript that got unsealed that I'm working on a piece on my Substack. Hopefully we'll get that out soon. But just a little bit of a deep dive into that little interaction with, God, what's the police officer? Brett. Sorry, I'm spacing a little bit now. His name's gone. Anyway, he testified about how the reason why they didn't check the other blood samples, the unidentified male DNA that was found in blood at the scene, the reason they didn't check that is because his understanding was that you could only put one suspect into CODIS. And so if they already had Mr. Kohberger, so if they put that in, it would boot him out. We're going to do a little bit of a deep dive into that, what he was saying, what the actual situation is, and what it means just in terms of a preview. How the defense needs to be prepared to handle this guy, Payne. It's Detective Payne. It came back to me. I'm sure you said it in the chat. I didn't see it, but yeah, the CODIS only takes one. It's like it's ridiculous on its face, isn't it? That's what he said, as if CODIS standards were not readily available public records that have been out there for years. But it's a warning to the defense. It's in many ways, this type of thing is a gift. It's part of why you do pretrial hearings, is so that you can vet these witnesses and get a feel for them, and have some expectations about what they're going to be like at trial, so that you can prepare your strategy accordingly. I'm going to have some recommendations for the defense when it comes to how to handle Detective Payne. So anyway, I'm working on that. I hope to get that out on Substack fairly soon. You know, long other list of things that are still going on. But we're going to get pretty hard and heavy into Karen Reed, real soon, assuming nothing happens and the trial doesn't get continued. So that's the plan for the short term, guys. I'll be back tomorrow. We'll watch this next set of hearings. Keep an eye on the Substack for stuff on Koberger. And yes, been working on that Turtle Boy interview with the jurors, so I can get a video out about that. Give you just some of my thoughts about that. Maybe I'll take a walk around here. Take a little walk around here and share you some of my thoughts about the juror interview. I don't know. We'll figure it out. But yeah, good to be back in the saddle. Good to be back. Good to be feeling energized and motivated and just enthusiastic about getting back in the saddle. Taking a look at some of these cases and seeing what we can learn from them. Learn about the case, learn about the system, where the system works, where it doesn't. Getting a lot of lessons in those these days. So with that, you guys, thank you guys so much for all being here today. Really appreciate it. It was nice to have such a good welcome back. Really appreciate all of you. Thank you for your support. Thank you to the mods that are here that I saw the wrenches going through in the chat. Of course, the one and only Jeff. Can't do it without him. Appreciate all of you. Look forward to seeing you guys again tomorrow. Be on it a little bit before 8 Pacific. And see what tomorrow brings. All right, guys. Take care, and I will see you tomorrow.